Yes.
My lord, kindly leave to mention item number 78 of my lord's list. My lord, in case the business of the court does not permit the matter to be reached, but could it be taken up tomorrow? It's a 2-minute matter. We are only seeking a report on the basis of which the bank is trying to declare us fraud. We have given letters several times. They're relying on a forensic audit report. They're not.
Mr. Gupta, it can only appear as an upgraded matter.
Yes, upgraded matter any day subject to
tomorrow, Monday.
I understand. Whenever.
Monday upgrade.
I'm sorry.
Your Lordship's kindly leave to mention one matter, Your Lordship. Yesterday, Your Lordship, a notice has been published by Canara Bank, Your Lordship, to sell the vehicle. Today, Your Lordship, at 3:30. 1 day notice, no notice under the SABYASACHI Act. May I come back at 2 o'clock or 3 o'clock as Your Lordship thinks fit?
3 o'clock original said, 2 o'clock Jalpaiguri matters are there.
Any time, Your Lordship.
Before tomorrow, we cannot do it.
Tomorrow.
Tomorrow top matter, I can fix it.
May I move it to Your Lordship?
Leave is granted, tomorrow top.
I'm grateful.
May I have my lord's kind leave to mention item number 29 under the heading upgraded motion, my lord. The work order to be issued tomorrow, my lord. And my lord, there is a palpable violation of the Article 14, my lord. The conditions of the contract has been changed after opening the bid.
Mr. Sinha, I cannot upgrade further.
Lord, may I have to mention, my lord, for upgradation of item number 392 of the combined list, my lord. I have mentioned earlier.
Why?
The ingress and egress of petition has been obstructed and by encroaching.
It will appear as an upgraded matter on Tuesday, December 5th.
My lord.
Upgrade.
And as a new motion to appear, my lord.
New motion will better appear.
No, list of 2022.
Not right now. Yes.
Leave to file, my lord. Section 14, my lord, order granted by the learned magistrate.
Is leave required?
My lord, leave is required. We'll file it today, my lord. My lord will allow me to matter to appear on top tomorrow, my lord, because already possession will be taken of my property, which is a property which was not mortgaged.
Leave is granted top tomorrow.
My lord.
On indulgence, my lord.
Permitted to mention, my lord, original side matter, my lord.
Original said when I take up original side at 3.
On indulgence, my lord, item number 31. This is a 10-day matter, my lord, likewise some lots of urgency. If your lordship, I am waiting for chance, if it doesn't come up today, my lord, if you not.
Further upgradation. Sorry. Call on.
Extension of interim order, item number 1.
When is it expiring, Mr. Basu?
30th, today.
I am appearing for the petitioner, my lord, with Mr. Basu.
Petitioner who is a complainant in the GRTC is not appearing. I think it can be.
I'll listen till disposal.
The
Pollution Control Board, man.
And I was appearing with Mr. Basu.
No, you're not happy. The interim order granted earlier is extended till disposal of the writ petition. Push up. Let the writ petition be listed for hearing in the monthly list of January 2024.
Grateful, dear lord.
Top item, item number 2.
My lord, I am for the petitioner and I am led by Mr. Ratnanko Banerjee. In this matter, on the previous occasion, was adjourned because the learned counsel, appearing for the primary respondent, Coal India, wanted to take instructions regarding the banning period. So our submission is that the banning has happened in 2016 on the day of termination of the fuel supply agreement. So on the same day from that time, the fuel supply agreement was terminated, coal supplies were stopped as far as the petitioner unit is concerned. And under the policy, which has now the last coal auction, when the writ petition was filed, the last coal auction was underway, but now that's ended. So our submission is, in terms of the coal policy, because 5 years have elapsed for the time of banning and suspension, so we are therefore eligible to participate in the upcoming auctions. So the new changes in the coal policy, earlier the coal was granted as per the fuel supply agreement, your lordship. But subsequently, from 2020, when the coal auctions were started, so the coal could only be granted to units such as the petitioner by...
You are challenging only the debarment.
Only the debarment, your lord.
That's what do you say regarding the time period?
My lord, what I have found...
Be short.
Yes, my lord. My lord, kindly come to page 101 of the writ petition. My lord, this is the first time they have been communicated that they were involved in misutilization of the coal. Now, my lord, in the present writ petition, their primary challenge is that...
I know the challenge. What is your stand on this? 5 years, it could not be more than 5 years.
Yes, my lord. So far as the period of 5 years is concerned, my lord,
this, my lord, could start from this 2021.
My lord, just to clarify the
In the
position.
please.
Yes.
In the 2021 communication, you have stated that the FSA was valid for a period of 5 years. You have stated
My lord, it is a detailed reasoned order.
this is not the first banning. It
My
was for something done by them previously.
Yes, my lord.
So you cannot grant a
But-
lease of life to
My
that.
lord, so far as this communication came
Communication is immaterial. The
in-
ban
in the year 2021. And
maybe.
the first time, my lord, they have been banned from participating, that is in, my lord, 2019. That is, my lord, my instruction. My lord, because the particular clause which is under challenge, that for pendency of the criminal case, you will not be allowed to participate. That clause, my lord, only came in 2019. 2019 June. So, my lord, there could be, my lord, situation. If we could, my lord, take the date from 2019 June, then, my lord, it will
Where
end
have you
on,
mentioned regarding the banning? At page 101?
my lord, banning we have not mentioned. But, my lord,
They'll be able to participate.
my lord,
There is no banning on record.
yeah, my lord, because, my lord, kind of kindly, my lord, appreciate your lordship was, my lord, only last.
What is the banning? You have to take instruction on when they were banned.
There is, my lord,
There is no order of debarment.
there is no order of debarment.
Then they are allowed to participate.
There is no order of
Learned
debarment.
counsel for the petitioner has raised an issue as to whether there was ever any order of debarment of the petitioner from participating in the respondent's tenders. Even if such an order was there, comma, in view of lapse of more than 5 years, which is the outer limit for such ban, comma, it is submitted that the petitioner should be permitted to participate in tenders floated by the respondents. Next para. Learned counsel for the respondents were to take instructions as to whether any order of debarment was specifically passed against the petitioners. Next para. When the matter is called on today, comma, learned counsel for the respondents places reliance on annexure P12 at page 101, which is a communication dated March 3, 2021, issued by the CCL within bracket Central Coalfields Limited, bracket closed, to the petitioner and submits that the said communication is the first order of banning. However, comma, the said communication does not disclose any order of debarment of the petitioner specifically. Next para. Thus, comma, since the respondents have failed to produce any document to show even prima facie that the petitioner was ever debarred from participating in the respondents' tenders, comma, the respondents, no, the petitioners are allowed to participate in all tenders floated by the respondents subject to eligibility otherwise. Next para. Accordingly, the respondents shall remain restrained from preventing the petitioner from participating in the tenders floated by the respondents during pendency of the writ petition, comma, subject, comma, of course, comma, to the eligibility otherwise of the petitioners to participate in such tender. Next para. It is made clear that such ad hoc order will be subject to the ultimate result of the writ petition. The respondents shall file their affidavits in opposition. Was there any direction? No.
No, Your Lordship.
Affidavit in opposition within 3 weeks. From date, reply if any shall be filed by the next filed on the next returnable date. The matter shall be listed on January 9, 2024 for hearing.
I'm grateful. Thanks.
application
Item 3.
for the applicant respondent.
Yes, Mr.
I have kindly straight away comes to your lordship's order passed earlier. In this matter, at page 22.
Yes.
I tell you, lordship need not go through this. This was an order. This writ petition was preferred, challenging the order of the learned National Green Tribunal by the writ petitioners. Whereby, the National Green Tribunal was pleased by their order to reject their application, original application. The allegation was that my clients are running a ceremonial house in Salt Lake.
Yes, yes.
Lordship remembers. We had said in the Green Tribunal also on affidavit, that has been recorded also, that we have stopped running the ceremonial house since February. I am wanting a modification of one paragraph. Your Lordship kindly takes paragraph 11 of your Lordship's order at page 24. Lordship has directed affidavits, but then your Lordship has said that during pendency of the writ petition, respondent numbers 8 and 9, that is the applicants, shall remain resident without injunction using the property in dispute for any ceremonial purpose whatsoever. Now, my lord, this application today is my lord, only seeking a clarification that, my lord, the son of the applicant number 2, my lord, there is a religious ceremony which is called Parojan ceremony. Parojan. I have stated in the application, which is a religious ceremony of this particular community.
What is the significance of that?
Well, this is generally, I've stated that this generally preferred when done for the male members of the family at a young age. But this is a religious function for the well-being and everything.
Yes.
Now, my lord, why I've stated in specifically time and again what I want to use these premises is because this, well, I've annexed the e-card also. Kindly takes page 27 once. The main function will be held in a particular hotel. The morning program and the evening rituals. My lord, these premises I want to use because only family, relatives and family friends, my lord, not exceeding 20, I've stated that also.
20.
I've stated that. My lord, I've made all accommodations
Date schedule?
for their accommodation purpose only.
When is the schedule?
My lord, they will have, my lord, the program is in the hotel on 7th, but they will come in from the schedule from 5th and leave on 11th, that I've stated specifically.
5th to 11th.
5th to 11th.
December.
Only for residential, December.
20 people are resident. Why is it not? Why is it not?
I'm not standing in the way. Only two clarifications, two clarification.
Action then I have to শেষ করে একটু শেষ করে নিন। My lord, I may possibly, this is as an abundant caution I tell your lordship because your lordship had specifically stated no commercial, no ceremonial purposes. So I could have used it, but my lord, since it is pending with your lordship, I want a clarification so that lest I be hauled up later.
Two things. One is my consistent allegation was they were using the open space of the premises for kitchen purpose, for the purpose. And my lord, in paragraph number 11, they have already stated they will not use this. They will not make any cooking activity in the premises at all. But then, my lord, kindly record that. My lord, this is the submit. And my lord, the second thing is the indiscriminate use of loudspeaker. From the inception, that was my lord matter of concern. And lordship, kindly let them use the loudspeaker within the permissible.
20 people will stay there. What will they do with the loudspeaker? They'll announce their presence.
In each and every occasion, they use the loudspeaker.
No, I'll restrict. Very well.
Only one.
Yes, what is the...
let them use the...
My lord, kindly have a look at paragraph 15.
What about cooking, Mr.
Kindly have a look at paragraph 15 at page 17.
What about cooking?
I've stated that.
Not cook.
I have stated that only purpose for which this concept will be in the is simply and solely for residential purposes. And paragraph 11, I say, furthermore, no cooking whatsoever will be conducted inside the premises, and relatives and family friends during their stay will only be served snacks and hot beverages. Specifically.
This is the noise rules, man.
Learned counsel for the applicant, comma, who is a private respondent in the writ petition, comma, contents that the Parojan ceremony, P-A-R-O-J-A-N, ceremony of the petitioner's son, comma, which is a traditional Marwari custom performed generally for the male members of the family, comma, is scheduled to be held this month, the coming month, puts up next para. For such purpose, comma, the petitioner is required to accommodate around 20 of his relatives in the subject matter of the present petition, comma, from December 5, 2023 to December 11, 2023, full-stop. It has been stated in the application and reiterated by learned counsel for the applicant that the purpose of user of the said ceremonial house is only for such accommodation, and no cooking activity will be done there during the said period. Full-stop next para. Learned counsel for the writ petitioner contends that the writ petitioner has consistently taken a stand that the present applicant uses loudspeakers discriminately during ceremonies in the said house, and also cooking activities are done in the open. Full-stop next para. However, comma, upon hearing learned counsel for the parties, comma, it transpires that the applicant stroke private respondent specifically avers that the purpose of use of the premises in question from December 5, 2023 to December 11, 2023 is only to accommodate about 20 of the petitioner's relatives and guests, and no cooking activity or use of loudspeakers shall take place during the said period. Full stop. Thus, comma, the said activity is not derogatory to the interim order passed on November 20, 2023. Full stop. Accordingly, can 1 of 2023 is allowed, comma, thereby permitting the private respondent stroke applicant to accommodate 20 of his guests stroke relatives in the subject matter property of the writ petition from December 5, 2023 till December 11, 2023. Of course, comma, without carrying out any cooking activity or creating any nuisance or use any loudspeakers. Full stop. No arrest to cause. Sergeant certified copies. Best please.
Recording by submission and cover this indiscriminately. Lordship, I have written that discriminately.
I cannot use that. I'll never say that.
Indiscriminate use of loudspeaker.
I'll never say indiscriminately, instead of indiscriminately, I'll never use discriminately. It won't come out of my mouth. Definitely not. Must be some mistake on your part. Next matter.
Well, applicant number
I'll never
two,
say indiscriminately. Instead of indiscriminately, I'll never say discriminately.
Wrongly heard.
Maybe, yes.
well, applicant number two, son.
Returnable date তো আগে করা ছিল। সেটা
This,
কি আসবে?
the son of the applicant number two.
আচ্ছা, very well. যেখানে son of the applicant বলেছি, son of applicant number 2.
I'm deeply honest.
No.
I'm deeply honest.
Next.
Am I sorry, bol?
Item 4.
4, yes. Who is appealing?
For the petitioner.
Yes. What is the matter, sir?
Petitioner purchased a land in the district of
What
Purulia
about service? Yes.
under section 46A of Chotanagpur Premises Tenancy Act.
Good service, Mr. Ghosh.
Yes, madam. All have received.
Section 40?
46A of Chotanagpur Tenancy Act.
Right.
Number the predecessors of the petitioners purchased the land. Number a suit has been filed regarding that property. Number I have applied for a certified copy of that order, permission granted by the deputy collector. If you also kindly come to page 12 once, annexure P1. This is a permission granted by the deputy commissioner of Purulia district. Thereby,
What is the year of Chotanagpur Tenancy Act?
it's 1908.
Right. CPC. Yes.
1908.
Right. Then
Now,
what
I
happened?
applied for the certified copy.
Of this order?
His order.
This is the certificate.
Now, this is a Xerox copy. I am required to produce before the learner trial court because the suit is pending.
How did you obtain the Xerox copy of
Well,
the certificate?
this copy was annexed with my cell deed.
Achha.
Now, I applied for the certificate.
Are the records still there? It's a 1964 order. They may not have the records.
This is a certified copy. The record room has accepted my lordship, my application for
I'll
certified.
give them liberty either to give you a certified copy within a limited period or intimate to you if the records are not
Yes,
available.
madam, that may be.
1964 records.
That may be.
Even High Court, some of the records are.
Since this
you'll have
document
to
is required
use-
to establish my right before the trial court.
I appreciate that, but secondary evidence, you can use this as secondary evidence. Anyway, the limited affidavit of service filed today be kept on record. None appears for the respondent. The limited grievance of the petitioner is that the petitioner purchased the property and obtained permission under the Chotanagpur Tenancy Act, 1908. To sub next para. An order to that effect was obtained on July 9, 1964, a certified copy of which is now required by the petitioner to assert his rights regarding the property. However, although the application for certified copy of the said order made by the petitioner has been accepted by the respondent authorities, no certified copy has been issued to the petitioner. Next para. It transpires that the date of the order, of which certified copy is now required, is July 9, 1964, and it is not clear before the court as to whether the records have still been retained by the respondent authorities. However, the respondent authorities are duty bound to decide either way, since they have already accepted the petitioner's application for certified copy. Accordingly, WPA 25540 of 2023 is disposed of by directing the respondent author. Which respondent?
Well, respondent number 1 is the district magistrate.
Respondent number 1 to ensure that a certified copy, ensure that either a certified copy is given to the petitioner of the order referred to above pursuant to the petitioner's application for such certified copy, within 3 weeks from date, alternatively, the respondent number 1 shall communicate in writing to the petitioner through his office as to why the said certified copy cannot be given to the petitioner, comma, if there is an impediment, if there is any valid impediment to that effect on the part of the respondent. Full stop. The parties shall act on the server copy without insisting upon prior production of certified copy, no rest to cause urgency.
Much okay. Great.
Item 5.
Lordship, I am for the petitioner.
Yes, Mr. Paul, what is the matter?
Yesterday, I made the submission that the tender process has been called off.
Yes, yes. Has been called off.
Here is the written.
Lordship, what happened, Lordship? I stood L2. I have challenged the credential of L1. And Lordship, I have made one representation. They kept themselves mum. When I filed this petition, they have cancelled it on 28th. When I served them, they have cancelled because
obviously afraid of you.
Their intention was to give the order. Lordship, Lordship, I have to challenge the cancellation order if my client is agreed and Lordship can pass the order.
Cancellation order of cancellation of the tender you will challenge.
I can challenge Lordship if there is no reason at all. Is the only administrative reason? What is the reason actually?
No, you participated and
I stood L2. What? I have challenged the credential of L1.
Learned counsel for the respondent authorities hands over a copy of a notice dated November 28, 2023, indicating that the impugned tender has since been called off within double inverted due to administrative reasons. Double inverted close, full stop, next para. As such, the writ petition, comma, it is submitted, comma, has become infractuous, full stop. Although agreeing to such proposition, comma, learned counsel for the petitioner contends that the petitioner was L1 bidder, L2 bidder in the said tender and reserves the right to challenge the cancellation, comma, if need be. Full stop. Next para. There is substance in such contention. Full stop. However, comma, in any event, since the writ petition has become infractuous, comma, there is no necessity of keeping the matter pending. Accordingly, WPA 26658 of 2023 is disposed of as infractuous with liberty to the petitioners to challenge the cancellation dated cancellation of the impugned tender, comma, if the petitioners so feel necessary, comma, in due process of law. Full stop, no rest to cause urgency.
We are in the process of issuing a fresh tender. So this liberty should not stand in our way.
No, nothing. What's the question of because they will challenge sometime, why should your tender be?
Video of service.
Video of service, right today, Captain. What like?
Upgraded matter, item 6.
I am appearing for the respondent, my lord, due to a change brief.
So what? No. Why did you take the change? You shouldn't have taken the change.
My lord,
can't prepare yourself. The day you take the change, you have to be prepared in the matter. No, that is one of the preconditions when in practice I used to follow. If I take a change, I have to be prepared on the same day.
That's true. I have intimated my client.
No. What is the urgency in the matter?
The urgency is, my lord, the petitioners are the member of a cooperative society in respect of the first matter. 6 and 7 more on the same issue, my lord, other sets of employees.
Yes, what is your prayer? You are wanting time for how much? How long?
My lord, I can file affidavit. There is
no question of affidavit. Well,
my lord, 2 weeks time.
Are you seeking an interim order?
No, I am seeking an interim order in the sense, my lord, that they let them not take any coercive measure. All of them are.
If you consent to that interim order, then take as much time as possible.
My lord, already, my lord, only, my lord, no notice has been issued, but no steps have been taken. So my learned senior friend has nothing to worry about.
So I'll pass that interim order then. Don't take coercive.
My lord, your lordship kindly fix the matter next week.
Not at your whims and fancy.
No,
I fixed it today. I can take up today. Next week will be another week. It's a different proposition altogether.
Lord,
I'll take it up today itself.
My lord, what is the latest position I have to know from my
only thing, my lord, I was
latest position regarding what?
My lord, so far, my lord, my instruction is concerned, my lord, over telephonic that my lord notice has been issued. If your lordship kindly comes to page 6.
The very move your matter. What is the
yes, my lord, the petitioners are, my lord, the ex-employees, pensioners, my lord, of Farakka Barrage project. My lord, Farakka Barrage project during 1959 to 65, my lord.
Please come closer to the microphone. Yes.
Now, during 59 to 65, my lord, they constructed some temporary quarters, my lord. Some of them are with asbestos sheet. Now, subsequent, my lord, those and this was situated, my lord, in a unclassified area at a remote place, my lord. Subsequently, those were abandoned. Now, my lord, the persons who were under the employment were the poor employees, my lord, with the poor pay. They had a, after retirement, they
You are
used to-
permanent employees? No.
Yeah, I was permanent employee.
Then what happened?
After retirement, my lord, I was used to get, my lord, 350 rupees pension. Now, the
Per
situation,
month?
per month at that point of time, now it has been enhanced up to 99,000.
9,000 per month.
9,000. Now, nowadays, my lord, after 6 pay commission. The situation is, my lord, since they have abandoned, my lord, we are, and we were staying, my lord, all along, we were maintaining, we were making the electricity bill payment. My lord, the system is, my lord, the Farakka Barrage Authority used to receive the license fee. My lord, a set of employee, my lord, moved before this honorable court in 2011 when my lord Justice Pinaki Ghosh, as his lordship then was pleased to direct the authority to receive the license fee under 45B of FR.
Of?
FR, financial rule, my lord. 45B of financial rule. My lord, thereafter again 2016, my lord, another set of employee who used to be, my lord, the state of West Bengal's employee, my lord, but were deputed to Farakka Barrage project. They also moved before the administrative tribunal, and matter ultimately came before the honorable court. There also, my lord, the tribunal was pleased to hold that FR 45B is to be made applicable. The situation is, my lord, since we were, my lord, under another association, and my lord, some others are there who are not under the umbrella of that cooperative society, we are being discriminated and we are being saddled with the license fee under 45A, along with, my lord, huge demurrage, which includes, my lord, a group D employee or a peon to the extent of demurrage to the extent of 2 lakhs rupees. This is the situation.
Where is the impute notice?
Yes, my lord, your lordship will kindly come to page. My lord, 45 and 62. These are the 2 notifications. And thereafter, even, my lord, they went to Delhi to meet the minister, to meet the secretary. Nothing had outcome, my lord. They were threatened that they will be evicted. Those notices are there, my lord. I could not, but they are in such a position, they cannot even move, my lord, frequently.
45 and
45 and 62. These damage charge, my lord, has subsequently been enhanced to 1,82,000 or to 2 lakhs.
No, I'll grant interim stay.
Your lordship,
Don't take coercive stay.
Your lordship,
These are
kindly-
poor employees
kindly
here.
record my submission.
What?
Your lordship, kindly come.
What submission?
Kindly come to the next page, 63.
Yes.
63 is the representation, part of the representation.
Kindly.
So you are prepared in the matter.
Yes.
Hello?
So you are prepared in the matter.
My lord, I have no alternative. My lord,
You have no alternative. That's why you became prepared in a second.
But I have to satisfy.
Then how are you placing page 63?
My lord, my learned senior.
How are you placing page 63 if you are not prepared?
My lord, I only yesterday I received the brief, I read it. The
Sufficient time. One night is sufficient.
My lord, notice of upgradation has not been served upon me.
No, earlier notice was served upon them, well, because I was not aware
Correct.
who is
Kindly
appearing.
appreciate
Page
my
63,
post.
what does it say?
63, kindly see. Para 2. The Department of Pension and Pensioners Welfare, they are withholding, my lord, the quotas illegally. And measures have been taken, my lord, as far as my knowledge is concerned, measures have been taken by issuing this notice. Now, this notice pertains to 23 December 2020. And
Subsequent that even in
till date-
2021 also.
till date, my lord, so far telephonic instruction I received in the morning, I must be fair before your lordship.
Since
that
my lord
no
is submitting,
steps for-
Please, let him. No, keep it with you.
My lord, no steps for recovery of any amount from their account has been taken by the authorities concerned. And that is true, it is clearly stated that no part of the gratuity could be withheld. That already it has been stated in the notice itself.
Learned counsel for the petitioner has made out a strong prima facie case for hearing the writ petition on merits. First up, the grievance of the petitioners is that the petitioners worked as employees in the Farakka Barrage project at a site which was subsequently abandoned. First up, the petitioners stayed on as licensees and sought application of financial rules for 45 capital B instead of financial rules 45 capital A, comma, seeking parity with other sets of employees who have obtained similar orders previously. Push up next para. However, comma, the impugned notices dated March 6, 2019 and January 7, 2021, annexed at pages 45 and 62, respectively, of the writ petition, comma, were issued by the respondent authorities, comma, seeking to recover huge amounts as demurrage from the petitioners. Push up, the legality of such claim has been challenged. Push up next para. Learned counsel appearing for the respondent authorities seeks an adjournment on the ground that he is appearing on change. Push up. However, comma, after the submission of learned counsel for the petitioner, comma, learned counsel for the respondents seeks to draw the attention of the court to the communication to the office memorandum dated December 25, 2020, annexed at page 63, where, comma, inter alia, comma, it has been indicated that no part of the gratuity was withheld at the time of retirement. Full stop next para. Learned counsel for the respondents, comma, as per telephonic instruction, comma, submits that the impugned notices have not yet been given effect to by recovering the amounts. Full stop next para. Learned counsel for the respondents also argues that the petitioners are retaining possession of the accommodations illegally. Full stop next para. Since the above questions are required to be adjudicated finally in the writ petition, comma, the respondents are directed to file affidavits in opposition within what time? Mr.
2 weeks.
Within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. The matter shall be listed in the monthly list of January for hearing. Full stop. The respondents shall remain restrained by an order of injunction from taking any coercive steps or giving effect to the impugned notices dated March 6, 2019 and January 7, 2021, annexed respectively at pages 45 and 62 of the writ petition, comma, till February 15, 2024 or until further order, whichever is earlier. Thank you. ওটা জানুয়ারি যেটা বলেছি month of January 2024. Thank you. I have recorded every single submission you made, including the ground for
Kindly appreciate, my lord, before upgradation, my lord, a notice.
Notice was given upon my lord, given to the general manager on 3 occasions. On 3 occasions. I am sorry, my lord, because I was not aware who is the learned advocate appearing.
What is the difficulty? If the general manager was given a notice, the difficulty is between you and your client. Follow on the next matter.
In all matters,
Item 7.
judge has to.
My lord,
That's not our problem.
My lord,
Yes.
the order passed in the earlier matter will govern this, my lord. On the same issue, another set of employees.
So should I record the exactly same order?
No, only, my lord, the pages are different because, my lord, some other documents are also there.
What is your stand in this?
But the same impugned notices and all other things.
Achha, you file your affidavit of service.
Yes,
in the next matter. Agetaতে affidavit of service filed today be kept record.
In both the matters.
Despite service, I am recording none appears. Despite service,
Appearing, but I have not received the brief in the next matter.
affidavit of next matter. Affidavit of service filed today be kept on record. Full stop. Learned counsel for the respondents submits that he has not received a copy of the brief. Full stop. However, comma, since service has duly been effected as per the affidavit of service, comma, the matter is taken up for consideration of interim orders. Full stop. The petitioners have made out a strong prima facie case as to the impugned notices being
Both the dates are same, my lord.
impugned notices dated. Give me the pages.
Yes, madam, I'm giving you. Do.
Dated আগের যে দুটো আছে same dated such and such annexed to the writ petition
Yes, madam. I'm just furnishing that.
are vitiated in view of Financial Rules 45A and not 45B having been applied to the petitioners, comma, who are ex-employees of the Farakka Barrage project and are continuing in possession in respect of abandoned sites. Full stop next para. The petitioner contends that that similar sets of other employees have obtained the relief of applicability of Financial Rules 45B, which should also be granted to the petitioners on the ground of parity. Full stop. Next para. Since a strong prima facie case for hearing the writ petition on merits has been made out, comma, the respondents are restrained from taking any coercive action on the impugned notices dated যা বললাম ওপরে, till February 15, 2024 or until further order, whichever is earlier. Full stop. Next para. The respondent shall file their affidavits in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Full stop. The matters shall be listed in the monthly list of January 2024 along with the previous matter, along with WPA 5978 of 2021. Thank you. Next.
Item 8.
I am both the petitioner, my lord. My lord, the matter related to the, my lord, the registration of Nirupam Putra, my lord, in the year 1990. That stamp paper was forged, my lord.
You want to put in the equivalent?
My lord, my.
Pass it on. Usual order.
My lord, kindly see the, my lord, page 31.
Without annexure, my lord, incomplete annexure, you can serve this to the petition.
Well, page 31, your lordship
That's why
order, my
my
lord.
do not take instruction, your lordship. Incomplete.
No, where is the document?
My lord.
Where is the document regarding which you want?
Page 15 is the documents, my lord.
15.
My lord.
No, the deed. Have you got a copy of the deed?
No, my lord. I'm not.
Nirupan
My lord, I applied for the certified copy, my lord.
Where is the Nirupan Patru?
Which is the registry, my lord.
Don't have a copy of that? You placed it for registration?
No, my lord.
Is it credible?
My father was executed, my lord. He was died, my lord.
I don't understand.
Earlier, my lord, I filed a writ petition, my lord.
At that point.
No, please, both of you cannot speak to. Yes.
Earlier, I filed a writ petition, my lord, before this honorable court, my lord.
That is the order annexed.
My lord, my lord.
Let us see that.
Order, my lord, page 27, my lord. Where
you don't have any annexure?
My lord, annexure, my lord. 20 to 27, my lord. Without annexure, my lord.
20?
20 to 27. Without annexure.
What do you mean by
Page
that?
19, thereafter, my lord, page 20.
Yes.
That's why, my lord, I could not, my lord, take instruction, your lordship.
Take instruction, give a complete copy. Affidavit of service filed today be kept on record. Full stop. Learned counsel for the respondent submits that complete copy of the writ petition has not been served. Full stop. Learned counsel for the petitioner is requested to serve a complete copy on his counterpart appearing for the respondent during the course of the day, including annexures. Full stop. The matter shall be listed tomorrow under the same head.
Fine. Great.
Tomorrow. Yes. Next.
Item 9.
May I please, madam?
Yes. What is that?
This is also a senior citizen matter, madam. Here the question is, my lord, that the petitioner's elder brother used to be a licensee, statutory license, my lord, under the signature of the signature on behalf of the President of India as far back as in the year 1970. Then, my lord, he became, my lord, ill. He handed over.
Statutory license means?
Statutory means, my lord, the licensee, my lord, the agreement which was entered into between the railway and the petitioner's elder brother,
yes,
was my lord, signed in the name of, my lord, the President of India.
Okay.
So it has a statutory flavor. My lord knows what is the statutory contract, my lord, under the article of the Constitution of India.
Then what happened?
Then, my lord, subsequently, my lord, the petitioner's brother was, my lord, running the bookstall at Baruipur railway station. My lord, he used to pay the license fee as usual as before. They were receiving the same. Then, in 2005, the petitioner's elder brother died. Immediately, my lord, they intimated. It is the case of the respondents, my lord, they did not get it. My lord, earlier I moved an application.
You are the only heir.
I'm the only brother, my lord. There is no the elder brother was, my lord, issueless.
So you are the only heir.
Only heir. Then, my lord, I moved a writ petition on earlier. In the meantime, my lord, a policy came out in 2007, my lord, converting the bookstalls, my lord, into MPS, multi-purpose stall, according to the new policy. There, my lord, there is a clause that those who are there, they can, on the terms and conditions of the present system, they if they apply, they will get it. He made the application, it was not done. The general manager rejected on the plea that there is no such provision. My lord, I moved earlier. Once, my lord, it was moved before up to the division bench of my lord Justice Banerjee. Since the policy was not enclosed, my lord, with the petition, my lord, the appeal was dismissed. I preferred the an SLP, my lord, before the Honorable Supreme Court. The Supreme Court returned back. If there is a policy, they will consider. They didn't do that, my lord. I moved another writ petition in 2022. My lord Justice Mousumi Bhattacharya was pleased to pass an order directing them to consider with the observation that the railways were sitting tight over the matter.
This time you annexed the.
Yes, I have, my lord. I have.
Yes.
Because the policy I got, my lord, subsequently from the website.
So after the direction of Justice Bhattacharya, what happened?
They, my lord, they didn't do that. They still took the same
Sitting
plea.
tighter.
No. They took the same plea. There is no such policy and all these things.
Show me that policy, just.
Yes, my lord. Your lordship.
The relevant portion, Mr. Ben. Yes.
Come to my lord, page, my lord, 15, my lord, at page 120, 121. My lord, this is the policy. It starts from page 115, 2017.
Show me the relevant portion, please.
Yes, my lord.
Yes.
120 and 21. Your lordship will kindly come. 11.3 at page 120.
Thank you. Yes.
The existing bookstall table other than such and such shall be given an option to convert the MPS subject to payment of license fee as quoted by the prospective bidder for similarly placed MPS unit. This is there, my lord. Then, my lord, next page at page 121, transfer of license. Transfer of license to the legal heir would be allowed only in the event of death of the original licensee. Nomination of the legal heir should be obtained from the license holder at the time of entering into the contract. Now, all these things, my lord, did not take its birth when the initial agreement was done in the year 1970.
There was no nomination.
So, no nomination, obviously, my lord, but at the fact remains, my lord, everything I submitted along with the power of attorney to run the business during the lifetime of the original license
This policy is dated 2017.
2017.
And you entered into that your brother entered?
Initial agreement, my elder brother in 1970.
So at that point of time, there was no such policy.
No such policy.
So therefore,
no such policy.
Very well. So then, this is the only bar.
This is the only bar, my lord, that my client, my lord, is old aged and my lord, practically, my lord, a layman. Unless and until such a...
You're a layman, how can you run a business?
No. Bookstall, my lord. MPS, multi-purpose bookstall, my lord. He is an inhabitant of Baruipur itself.
Right.
Only thing, my lord, that on any terms and condition as along with others, if I am given a... Not only that, one more, my lord, startling fact is,
yes,
the bookstall which was constructed on the railway, but it was done at the cost of the petitioner's elder brother by himself. And the railway, my lord, have broken it, my lord, by using the force.
Now you are not in possession.
Now I am not in possession. My lord, I should be candid. That's
when were you dispossessed?
But that is in 2018-19. After making payment of all area dues.
2005, your brother died?
Yes. And all these years I was continuing till 2018, 18-19. And since then, my lord, I am running before this honorable court, my lord, one after another.
Yes, what do you say?
My lord, I appear for Union of India and Railways.
Right.
My lord, first of all, this is the second round of litigation. When
Is the microphone on? Is the microphone on? Switched on?
My lord,
Yes.
My lord, can you hear me?
Yes.
My lord, this is the second round of litigation.
Right.
Learned single judge went through the matter that representation was not considered at that time. But there, after the learned judge passed the order, we have considered their representation, passed a reasoned order, which is on page 130.
129 to 132, my lord.
What is the sticking point? That there is no nomination? My lord, my lord will for once come to page 169. The railway stall, that bookstall was demolished by court order.
No.
Yes.
Not court order. I'm sorry.
No, let her finish. Yes. Yes, page 169. Yes, my lord. Where this is a division bench order. Annexure M37, I think 169 was from the previous petition.
My lord, demolition took place earlier to it.
Because, my lord, there's a learned single bench judgment where,
So at that point of time, already the transfer of license prayer was rejected previously.
my lord, transfer we did not get. My lord will understand there was an initial agreement with the petitioner's elder brother,
Yes.
which was time to time extended. After that time it was run by the catering department of the railways. After that, a completely new policy came, which my learned friend has shown. By that policy, if you were a license holder, you had to exercise an option of nomination as per that agreement, that policy. Otherwise, I could not transfer.
But at the time when the initial agreement was entered into,
Yes, it was.
This clause was not there.
This clause
So
was
how
not.
could they have anticipated at that point? Retrospectively, how can you do this? I mean, in 2017, you put in a clause and say if at the juncture when the agreement was entered into, there was a nomination, I'll then allow. But this clause was not there.
This nomination was in 2017 in the new policy. The new policy gave the right to nominate your heir if you wanted to. You had to exercise that option.
Let us come to page 121.
Yes.
Clause 16 says, the second sentence of that, nomination of the legal heir should be obtained from the license holder at the time of entering into contract.
Yes.
This is the new contract which will be entered into.
New policy.
This is the policy.
Yes.
The entering into contract is the new contract which will be entered.
Entered, yes.
But at that point of time, the legal heir was already dead. In this case.
Yes.
In his case, he was running.
No, my lord.
He was not
He was running the stall, but there was no formal agreement. He was signing on behalf of his brother for Santosh Cha.
And Justice Banerjee's division bench order is also there, which dismiss the appeal against the eviction.
Yeah.
No, not against the eviction, man.
So these are your arguments.
No, my lord also will see.
Yes.
Will come to page 168.
Yes.
Yes, this is the eviction. And my lord, the single bench judgment is on page 166.
So at that point of time, it was held by this single judge that he was liable to be evicted.
Yes. And my lord, once will come to page 150, which is the clarification note.
After this entire exercise, Justice Banerjee's order, division bench and all, he has applied again.
Yes. Applied, no. He made a representation that please allow
Which has
me.
now been turned down by you.
Yes.
Page
Which
150?
has now been turned out by the railways.
And 150, you are showing something? 150?
No, that's a clarification that when like the existing stallholders, existing means his brother. I mean, there would be a status quo until there was a Supreme Court.
That is now redundant.
No.
So let me hear him. Yes. Yes, what do you say, Mr. Banerjee?
Thing is, your lordship,
It has attained finality against you.
I'm coming, my lord. after the order passed by the division bench, my lord, I preferred an SLP. SLP was not entertained, but give a cue that if there is any policy, he will make an application.
Let us see that order, page 171.
Yes, my lord. Your lordship, we kindly see.
Eligible to apply for any other scheme, he may
Yes.
do so.
Yes.
You are not eligible.
No, I'm eligible, my lord, on this. Your lordship, kindly appreciate, my lord, this thing. Kindly appreciate, but I'm explaining. Your lordship, now kindly see what was the license, because my lord Justice Mantha, with deepest respect, madam, I'm submitting. When the order was passed, my lord Justice Mantha did not consider, my lord, the agreement at page. My lord, your
Mr.
lordship.
Banerjee,
No. Your
you
lordship,
have to, no, you have to take notice of a simple thing. The Supreme Court says we clarify that if the petitioner is eligible to apply for any other scheme.
Yes.
This scheme which you are relying on
Because this
was
scheme-
already in force at that point of time.
Yes, but the thing is,
No.
since the scheme was not placed on record before the division bench,
Maybe.
it was rejected on that ground. Your lordship will kindly appreciate.
The language of the Supreme Court is any other scheme.
Yes.
Other.
Now, my lord, even then, my lord, your lordship kindly appreciate, my lord. Kindly appreciate, my lord. It's not in despair. Thing is, my lord, an MPS is there, MPS system is there. New persons are making an application. I am, my lord, making, my lord, every prayer to every nook and corner that even in terms of the present system, I may be allowed one MPS on the strength of the payment.
You are not in possession for 5 years.
Be that as it may, it's not that, my lord. It's not, my lord, alteration. Let them give a fresh, my lord, of MPS.
What is your age?
But age is, I'm coming, my lord. Precisely, age is.
And my lord, all along he has signed on behalf of his brother.
But 68 years.
68, then I'll not impose costs.
My lord, your lordship, kindly appreciate.
No, I'll not impose costs because you are 68 years old.
My lord, your lordship,
Almost a septuagenarian, I'll give benefit of the age to you. But this would have been rejected. This is the second, not the second, the third round of litigation.
Third round of litigation. Your lordship, kindly, for my satisfaction, kindly come to page 43.
43.
Your lordship will appreciate that whether.
But even if I come to page 43, Mr. Banerjee, you won't be satisfied. So your satisfaction does not arise here.
No. Because, my lord, this is an agreement what I was contending.
Yes.
That this was an agreement, my lord, in the name of the President of India. Now, under the statutory, if it is statutory agreement.
So many things are being done in the name of the President.
Right, absolutely right. But still then, the moment it is given, it gives a statutory flavor. Whether, my lord, by use of this physical force, my lord, I could be evicted in this way without resorting to the eviction of unauthorized occupant. Kindly consider this aspect, my lord. What
this agreement is of 1986, not 1970.
No, it is a renewal. It is a renewal. Initial agreement, kindly come to Annexure P1.
Very well.
Kindly
No,
come
Mr. Banerjee, I'll dismiss your application. I'll give my reasons. Learned counsel for the petitioner contends that the petitioner is aged about 68 years and has been running from pillar to post. So the petitioner's brother was initially the holder of a statutory agreement for license in respect of a bookstall in the premises of the railways since the year 1970, which agreement was renewed from time to time. Learned counsel submits that the said agreement had a statutory flavor, since the president was a signatory there. Next para. It is contended that the brother of the petitioner met his demise in the year 2005, after which the petitioner has been de facto running the stall. Subsequently in 2017, a policy was adopted by the railway authorities, to grant such stalls as MPS within bracket multi-purpose stalls bracket closed to the nominees of the licensees. Next para. The petitioner duly applied for coming under such scheme, which was refused by the railway authorities. The matter ultimately went up to the Supreme Court, where a leave was granted to the petitioner to apply for any other scheme, if the petitioner is so eligible. Learned counsel submits that the petitioner is fully eligible to get the benefit of the 2017 scheme, which was floated on September 5, 2017. But the railway authorities have unlawfully refused to give such benefit to the petitioner. Next para. Learned counsel for the railway authorities submits that although there was a previous direction by a coordinate bench on the railway authorities to consider the representation of the petitioner, the same was duly considered and has been rejected on cogent grounds. Insofar as the petitioner's brother is concerned, the said brother, who was the original licensee, had died in the year 2005. Push up. Thereafter, the petitioner had applied for grant of license to him, which was rejected, upon which a writ petition was preferred. Push up. Upon the said writ petition getting dismissed, an appeal was preferred, which was also dismissed, affirming the order of the learned single judge. Push up. Ultimately, the Supreme Court dismissed the SLP as well. Full stop. It is submitted that the clarification in the Supreme Court order pertained to some other scheme. Full stop. However, the 2017 scheme was already in force at the relevant juncture when the learned single judge and the division bench passed their orders in the first round of litigation. Full stop. Next para, learned counsel also relies on clause 16 of the 2017 policy, which stipulates that nomination of the legal heir should be obtained from the license holder at the time of entering into contract, which is not the present case. Because of that apart, the petitioner has been dispossessed as long back as in the year 2018 pursuant to the orders of the court. Full stop. Next para, learned counsel for the petitioner controverts such allegations in reply and submits and denies that the eviction was in terms of any order of court. Full stop. Next para. A perusal of the materials annexed to the writ petition clearly shows that the chapter which is sought to be reopened by the petitioner at present had already been closed long back, at least 5 years previously. Full stop. Next para. Video order dated November 1, 2018 passed in WP 22071 within bracket W of 2018, in the writ petitioner's challenge to a rejection by the railway authorities of his prayer for transfer of license issued in the brother's name, the learned single judge observed that the writ petitioner is an illegal occupant of the said bookstall and is liable to be evicted. Pushed up. Next para, the railway authorities were directed to take immediate steps to evict the petitioner from the bookstall and also take steps for recovery of any occupation charges from the petitioner post the death of the original allotee, late Santosh Kumar Rai, the petitioner's brother. Pushed up. In the appeal preferred against the said order, a division bench of this court not only dismissed the appeal and affirmed the order of the learned single judge, it was clearly observed in specific terms that the appellant, that is the present petitioner, confirmed that he had now been removed from the Baripur station. Push up. The division bench observed in the order dated February 3, 2020, that since there was no merit in the matter, as it did not appear that the writ petitioner or his predecessor in interest was inducted upon any competitive process being conducted, the writ petitioner could not have claimed any right to remain in occupation of the railway premises or continue to run the bookstall indefinitely. Push up. It is noteworthy that the order of the learned single judge was passed on November 1, 2018, which continued up to the division bench, which passed its order on February 3, 2020, and the Supreme Court passed its order on November 18, 2020 in the SLP preferred by the petitioner against the division bench order. Push up. Hence, the entire exercise of orders being passed took place after the date of the policy of 2017 on which the petitioner now relies, which was dated September 5, 2017. Pushed up. The Supreme Court dismissed the special leave petition of the petitioner with the clarification that if the petitioner is eligible to apply for within double inverted any other scheme, double inverted clause, he may do so, which request be considered in accordance with law. Push up. Next para, by using the expression within double inverted other, double inverted clause, to prefix the expression single inverted scheme, the Supreme Court made it clear that it was not referring to the 2017 scheme, which was already in force at the relevant juncture, although the petitioner argues that the same was not considered by the learned single judge. Pushed up. Next para, the petitioner got an opportunity to point out before the division bench as well as the Supreme Court that the 2017 policy was not considered by the learned single judge. Full-stop, having not done so and not advanced arguments on such count, comma, the said issue is now barred by the principle of constructive res judicata. Full-stop, next para. Hence, comma, the petitioner cannot reopen the entire issue at this belated juncture, comma, 5 years after the order was passed by the learned single judge, and pursuant thereto, comma, the petitioner was dispossessed from the property. Full stop. In any event, comma, there does not arise any occasion of any nomination of the nomination by the original license holder, comma, since the original license holder met his demise in the year 2005. Full stop. Hence, comma, there is no scope of interference in the present writ petition, and the railways were justified in rejecting the renewal of prayer of the petitioner to be granted a license under the 2017 policy. Full stop. Accordingly, WPA 309 of 2020.
My lord, we have also considered the representation as per the
I've said that.
last.
Accordingly, WPA 3309 of 2023 is dismissed on contest without any order as to cost. Full stop. It is made clear that keeping in view the advanced age of the petitioner, comma, no costs are being imposed on the petitioner, despite the petitioner having sought to abuse the process of court by this third round of litigation.
Deeply obliged.
Oh, that's my lord.
So that you don't file the fourth writ.
No. It will not be done, my lord. Thing is,
You will not be there. Somebody else will be there.
only thing, my lord, that the 2017 could not be placed before the learned single judge or the division bench along with the petition because it was not there.
Not only that, you did not argue. No argument was advanced on 2017.
The division bench categorically said, why didn't you enclose? Question is this, man. A policy was not.
Anyway, Mr. Banerjee, matter is over. Yes, next one.
Item
Item number.
Item 10.
My lord, I'm paying for a passover. My lord, I mean,
You move the
by.
matter.
My lord, I'm praying for not put my lord because
My lord, I will.
GN race has come to
Then it
But I
goes
think
down the list. It's an upgraded matter. If you pray for time,
My lord, I'm just paying for a short passover.
What is the urgency in the matter?
My lord, this is implementation of a scheme under the. My lord, I will just place the supplementary affidavit.
Who is leading you?
My lord, Mr. Ratnanko Banerjee, learned senior.
You start the matter.
My lord, it's a short matter. My lord, I'm afraid that my lord, short passover.
If it's an upgraded matter, I cannot grant it.
My lord, I'll just.
Why are you praying for time?
my lord, Mr. DN race has responded, my lord, he has not due to some personal difficulty. So I'm
Not?
not today, my lord. Not
He has not come to court.
yes, my lord. Due to some
Are you sure he has not come to court?
Yes.
My lord, then not today, my
I'm
lord.
praying for only not today.
My lord.
An adjournment is sought by the respondent on the personal ground of learned counsel for the respondent. Push up. Let the matter stand over for the day.
My lord.
Same heading as.
Get.
Tomorrow you have to be ready.
My
Mr.
lord, I will
Banerjee
be
is
there.
not there.
My lord.
Item 11.
Yes.
My lordship directed to file affidavit.
Lord, Lord, the affidavit is otherwise ready, my lord. I am very embarrassed to pray for only 2 working days to file it, my lord.
2 days.
Well, it's a money claim, my lord. I'll take the point of maintainability.
Not claim. It
Ms.
is
Roy
demand.
Mukherjee, the difficulty is the court will be handicapped without their affidavit to decide on merits. That is the difficulty. Because it's a money claim, he has pointed out rightly. Mr. Banerjee is clever enough to point out the right aspect of that. If it's a money claim, we have to look into their affidavit.
Not claim. Again, I'm submitting before a lordship. It is
Demand.
demand. It is demand because they have certified who has served the report, who has filed the report.
How do you distinguish between claim and demand?
That is a claim. That is the another thing that is disputed. Then can claim it. And demand means that is the certified.
Claim may not
amount.
be disputed.
No,
Demand may be disputed.
it is their.
I may dispute
document.
your demand, but
Yes,
I may admit
but
your claim.
that documents on that basis I'm demanding.
Learned counsel for the respondent, you are for the Bidhannagar Municipal
The
Corporation.
corporation, my lord.
Learned counsel for the Bidhannagar Municipal Corporation seeks an adjournment, seeks an extension of 2 further working days time to file the affidavit in opposition. Full stop. Accordingly, the time for filing affidavit in opposition is extended till December 4, 2023.
Grateful.
Reply, if any, shall be filed. How soon can it
Within 3 days. Sir.
Reply, if any, shall be filed by December 8, 2023, when the matter shall be listed under the same heading.
I'm grateful.
Grateful, my lord. Extremely grateful.
Next.
Item 12.
Hey, please, your lordship, this is my
Yes, Mr. Ghosh,
requisition.
what is the matter?
So this is arising out of, my lord, an order passed by the DRT, Debt Recovery Tribunal, my lord, affidavit of service, my lord, where my property is being attached. Whereas, my lord, I'm not even the borrower and I have no connection with the proceeding in which, my lord, the property has been attached.
Why don't you file a section 17?
My lord, I couldn't have because, my lord, I only came to know of it at the stage of a section, at the stage of certificate proceedings, my lord. Certificate issued by the Ranchi Debt Recovery Tribunal. Thereafter, it was transferred to the
Sale certificate has been issued.
Yes, my lord, for recovery of the debt, not sale certificate, my lord. So I have the original title deeds with me. So there couldn't have been any.
If you could prefer the writ petition, you could have gone before the tribunal.
Well, we preferred an intervention application before the debt recovery tribunal. Debt recovery tribunal has dismissed it on the count that I do not have any.
What you cannot do directly, you cannot do indirectly.
Well, the writ, my lordship will kindly consider this, my lord, in violation
Challenge
of
that order in before DRAT. No.
My lord, it's completely in violation of natural justice, my lord.
What natural justice?
My lord, this law is also there, my lord.
What was also there?
Well, lordship will kindly see 11, 12, and 13, my lord. In case, my lord, of DRT where there's violation of natural justice, my lord, I come up.
What natural? Every case is national known. Go before the appellate authority.
Lord,
if your intervention,
if your lordship is satisfied with the facts, then your lordship.
What is the
yes, lordship? The attachment order is at page 49. Lordship will kindly at 47. It's pertaining to, my lord, a third party, which is, my lord, the respondent number 3. We have made them a party here as well.
Yes.
Lordship will see it's against Bokaro Motors Private Limited. Now, my lord, the attachment is of their claiming to be their property. The schedule is at, my lord, page 48. This schedule is of my property, which is at, my lord, page 33.
You say you have no connection whatsoever?
No connection whatsoever.
We have the deed.
The original deed, my lord, I am carrying it before your lordship.
So where is the rejection of your intervention application?
Yes, my lord. That is at, my lord, page 199.
What have you challenged here? That rejection?
I have challenged the rejection because original proceeding, the certificate, my lord, I have to go before Ranchi. I have said that no steps be taken pursuant to the certificate and, my lord, the rejection.
The property is here.
Property is here. 15th of May 2023.
No. Where is the rejection of your intervention application?
Well, this is
199 is.
Well, at 201, that is the order, my lord. There's the specific rejection is that, my lord.
No, as the intervening application is already
I'm so sorry. I'm so sorry. I'm so sorry. My 180. I'm so sorry, my lord. 180. This is 2nd of August 2019 at page 181. The claim of the certificate holder applicant for the mortgagor, property in question has been decided by tribunal VD such and such. Recovery officers not vested with the power.
Not vested with power.
Anomaly, my lord. Hence, the issue of validity of attachment in question has been raised by the intervener claiming lawful possession cannot be decided by the recovery officer.
So why didn't you file an independent application before the tribunal?
Lord, then I have to go back.
Recovery officer has a point because it's not like Order 21/101. Recovery
Yes,
officer
it's
is not
not like that. But my lord, my property, because now what has happened is this, my lord. Subsequently, the receiver has been directed to take assistance from the police and recover the property from me.
You should have gone before the tribunal with an independent application. What is your reason for not doing that? I don't understand.
If I go before the tribunal, I'll be accepting jurisdiction of the tribunal. I am saying that the tribunal has no jurisdiction whatsoever over my property.
Which tribunal is in season?
My lord, the DRT Calcutta.
What do you say, Mr. Palchoduri?
Certificate is issued by DRT.
They say they have no excess. Show me one excess.
Kindly come page 95.
Page
95.
Page
95. Petitioner's father sold the property to the borrower, and that property is mortgaged to us. Yeah, but a purchaser is our borrower, and they mortgage the property with us, and we proceed on the basis.
No, the borrower is someone else. Pritish Chandra Chakraborty and Tanuja Chakraborty were the purchaser.
Yes.
The borrower claims to them.
Borrowers purchase the property from the.
Borrower is some Bokaro something.
Bokaro is the company, and they are the guarantor. And kindly see the certificate.
No, Mr. Ghosh, you have to approach the tribunal. Learned counsel for the petitioner, because if I say much, then your case will be prejudiced.
Yes, sir.
Learned counsel for the petitioner contends that the petitioner has no connection whatsoever with the judgment debtor. but in the garb of a recovery proceeding, comma, the petitioner's property is sought to be taken away. Whose sub next para? Learned counsel for the bank controverts such submission and submits that there is a nexus between the petitioner and the borrower, inasmuch as the petitioner's father had sold the property to the predecessor in interest of the borrower. Pushed up. It transpires from the records that the petitioner sought to intervene in a recovery proceeding, which was turned down by the recovery officer on the ground of lack of jurisdiction of the said officer, which order was also affirmed subsequently. Push up. Learned counsel for the petitioner submits that uh, since the impugn action of the bank is palpably without jurisdiction, comma, the principles of natural justice has been violated and the writ jurisdiction ought to be invoked. Full stop. Next para. However, comma, a factual dispute has arisen as to whether the petitioner's predecessor had transferred the property in favor of the borrower and not the borrower's predecessor, comma, which would be germane in adjudication of the issue. Full stop. Thus, comma, it would not be prudent for the writ court to entertain the writ petition, comma, thereby taking upon itself the task of factual adjudication of disputed questions of fact, which require assessment of evidence. Accordingly, WPA 18900 of 2023 is dismissed as not entertained. Leave is granted to the petitioner, comma, however, comma, to approach the appropriate tribunal with the challenge as preferred in the present writ petition. If so approached, comma, the concerned tribunal shall decide all issues in accordance with law independently without being influenced in any manner by any of the observations made herein. Nor as to cause.
So great.
As I said. Mr. Ghosh, what was your assessment? How long it would take before this court?
This matter.
How soon it would be dismissed? What was your assessment?
Around 2 minutes.
You did a good job then.
So great.
Adin. Yes.
My lord, may it please your lordship.
Yes, Sanad.
My lord, although the subject matter of the dispute, my lord, may I file the affidavit of service? Subject matter of dispute is very short.
Respondent bank, my lord.
But my lord, the point of law involved is very interesting.
Yes.
My lord, what happens, my lord? May I just give a background and then, my lord, take your lordship to the necessary thing. My lord, my sister, I was looking for, my lord, parking space. My sister is the owner of a flat, which has, my lord, also a parking space. Now, the parking space, two things, 139 square feet, and, my lord, that is...
You were also a resident of the same apartment?
No, just very close by. So what she did, my sister, she bought this from the developer. Now she gifted me the garage space to me, the undemarcated 139 square feet. Now, my lord, I am not a borrower, I am not a guarantor. Suddenly, my lord, it seems, my lord, we receive a notice from police station saying that you come. I went there and it was told that one person has purchased a garage space. Whether that is mine or not, I don't know. So after that, he lodged a complaint against the authorized officer, saying that, see, I have paid the entire money, 2 lakhs and odd, but you are not allotting me this garage space. Now I responded to that. Say, I am not a borrower.
No, I don't get this point. Who made the complaint?
Private respondent. Private respondent purchased the one garage space in the same area, 148 square feet. That is the difference.
From whom? Your sister?
No, from the bank. From the bank, SABYASACHI action.
Oh, that's it.
And then lodged a complaint against the authorized officer in police station saying, see, that I have paid entire money, that I am not getting possession, I am not getting anything. So I went to the police and my lord responded that, see, I got it by a registered gift deed. I also gave the chain deed that 139 square feet is my parking space. Now, all of a sudden, in the month of July, the possession of my garage space was taken by the police and the bank. And my lord, also a possession notice was affixed. And then, my lord, I wrote a letter, but under what authority you have taken it? Show me that this garage space was indeed given to you. Now, my lord, the RTI given No response to the RTI. Now, my lord, when I issue the demand justice, the bank says, my lord, very important, my lord, kindly come to 109. Very important. The bank says, your property is different. Your property I have not taken possession and denied to give me, kindly, my lord, see, kindly, my lord, 109. We acknowledged the receipt of your letter. Notice dated such and such, received by us on such and such. We have gone through the contents of the same, and your reply is under. At the outset, we deny all the allegation that one property, car parking space measuring about, kindly mark this portion, 148 square feet on the ground floor of Block B, Pitha apartment, such and such, mortgage to a bank loan in account of security. That the bank as secured creditor has taken physical possession of the said property, being secured assets with the lawful assistance of the district magistrate, South Chobbish Pargona, as per order dated 7/12/2002, 22, passed under section 14. That the property and deed of conveyance referred in your notice is distinct, mark this portion, from the secured asset of the bank and not the same property. Then it is to state, bank being secured creditor has taken all required lawful legal recourse as prescribed under the provision of said act, and the security interest rules in respect of the said property for realization dues of public money. Hence, your allegation that forceful illegal possession taken without due process of law is not being tenable, being baseless, devoid of meaning. For documents, etc., as call upon us, it is to inform you that the documents information held by the bank are in fiduciary relationship and not shared disclosed to any third party.
So what do you challenge here?
I challenge, my lord, the act of possession, as well as, my lord, I want a declaration that this property does not come under the purview of section.
That it could will gladly do that.
My lord, kindly, my lord, the action.
Declaration from
my lord, I said, my lord, the action to declare the action illegal, my lord, on the part of the bank. No, my lord, kindly, my lord,
not ascertaining whether the properties are the same.
Lord, that's the question.
No.
No, my lord, 1 minute, 1 minute, my lord.
We entertain this sort of writ petitions.
No, I am not. I am not saying. I am not saying that. My lord, two things, my lord, 2 points of law I want to argue before your lordship.
Your husband is specializing in these matters nowadays.
My lord, 2 points of law I want to argue. My lord, 2 points of law. My lord, first is
what 2 points of law?
My lord, first is the secured asset has to be well defined, well demarcated in terms of the act. If the secured asset is not well defined, well demarcated, I will show from the rules itself. Then, my lord,
yes, obviously it has to be.
Second is, my lord, under the SABYASACHI Act or the District Magistrate Act under Section 14 has no right of partition of our property. So therefore, on the basis my property, when they say it is distinct, the possession should go. Now, my lord, kindly take, my lord, the rules. And also, my lord, third point is, I'm supported by a judgment of this court, that, my lord, after the possession is taken, after the sale is completed, my lord, Section 14 order cannot be passed. These are the 3 points I want to emphasize before your lordship. And if
here Section 14 was passed after
the sale. So these 3 points, my lord, if I succeed, I am going to get back the possession. My lord, the first, my lord, lordship says, my lord, Rule 8.6, Rule 8.6 of the SABYASACHI Act, my lord. I will be very brief before your lordship.
Flag.
Yes, thank you.
Now, my lordship says Rule 8.6. The authorized officer shall serve to a borrower a notice of 30 days for sale of the immovable secured asset under Sub-Rule 5, provided that if sale secured asset in being affected by either inviting parties, holding public action, secured creditor shall serve public notice in form of Appendix 4A. Now, let's kindly come to Appendix 4A first. Now, lordship will see also, my lord, kindly take Appendix 4 also. Well, lordship sees the property has to be defined, bounded on north, on south by, on east by, on west by. And then also my lord, when the sale notice is issued, my lord, the details of the property has to be given. So that is the first point. Second, my lord, rule appendix 4, and then also takes, my lord, rule 871. 871, lordship will see
87A.
87A. The description of the movable property to be sold, including the details of the encumbrances known to the secured creditor. Now, my lord, rule 87 is, my lord, appendix 5. My lord, lordship will again see.
Yes.
Again, my lord, bounded on north, on south, on east and west. Now, my lord, here, so the property, now, my lord, kindly have a sale deed of my sister. That is, my lord, at page 61 is the schedule. And all parking space there are undemarcated in that building. Number 61, lordship will see what was conveyed.
Nag, this fact-finding exercise cannot be. Suppose your contention is correct. You have purchased an undemarcated portion. All the parking spaces are undemarcated. This person claims, the borrower claims to have, mortgaged a demarcated portion, and whatever they have taken.
No, undemarcated.
They have also taken undemarcated.
Undemarcated.
So your grievance is basically that this undemarcated portion could not be taken, and your portion has been taken.
Yes.
How can this a fact-finding exercise has to be gone into?
Because on the basis of the admission on the part of the bank.
How can this be a palpable jurisdictional error?
Well, I tell you, lordship, my lord, if, my lord, I want to, my lord, raise my argument to that level, saying that if, my lord, say, my lord, a land, if it is undemarcated, not only I have a right over the property, my lord, but I also have a right of easement over the property.
Do you say an undemarcated property cannot be mortgaged?
Cannot be, no, can be mortgaged. Then, but that does not come under the secured asset if it is not well defined.
Whether it's a secured asset, whether it fell within the secured asset, that has to be ascertained by facts.
Lordship.
On facts.
My lord, kindly, my lord, appreciate this situation. Now, what we are in, my lord. Now, my lord, I am not a borrower. I am not a guarantor. The bank said it is a distinct property. And again, my lord, my property is taken.
As a third party, you also have a right.
The correct.
Go before the
But, my lord, kindly also see the judgment of.
Right is affected, go before the tribunal.
Well, kindly take the judgment. Even, my lord, I say, my lord, they sold the property. They sold the property in Kundit. They sold the property.
You have to challenge the sale also, Mr. Nag. Not mere possession.
No.
Yeah, unless you challenge the sale,
no,
by virtue of the sale, your right is
I go by the admission of the bank. Now, my lord,
your only remedy is a civil suit, basically. Why I say this, Mr. Nag? Because you have to challenge the sale. If you don't challenge the sale, you seek possession, restoration of possession. That cannot be given now to you because somebody else has got title over that property by virtue of this auction.
No, title of not my property. That is the issue I want to say.
Particular property.
My lord, I say, my lord, if the property is not.
If you say he has not got title of a property, the bank says he has got title of.
Bank is not saying. That is the
bank
point.
Is not saying, so you don't have a cause of action.
No, bank is not saying. But indeed, my lordship says, my lord, they have to follow the statutory mandate.
X property has been sold. You say it's your property, bank says it's not your property.
No, bank is saying X property is sold, that is not your property.
So it's a title dispute. You have to decide get that adjudicated before a civil
court.
My
lordship says
no.
My lord, my theory is, my lord, the statutory mandate has not been complied. My lord, lordship sees the 86 and
statutory mandate has not been complied. You go before the tribunal.
No, my lord,
third party.
My lord, lordship says, my lord, I am also having a division bench judgment in this regard. My lord, if I am not, my lord, a person who is no way connected, not even, my lord, it can be, my lord, my property.
The evidence taken by the division bench is also annexed with it. The certificate copy of the evidence must have taken evidence.
Lordship says,
without taking evidence, this could not be decided. The division bench must have taken evidence.
Here the case was same. No, third party. Lordship sees the division bench judgment reported in 2010 SCC online, Calcutta.
Show me the certified copy of the evidence taken by the division bench also.
That's not I am saying that. But
see what has been decided here.
My lordship says 11. We are of the view that in the facts of the present case, where a citizen has been harassed in this way and was dispossessed from his lawful property at the instance of financial institution who had acquired no interest over the property in question so as to enable it to exercise power conferred under section 13(4) of the Act, such citizen is not required to go to the alternative remedy provided under section 17 of the Act. In that case before us, neither the writ petitioner nor her predecessor had ever secured the property in favor of IDBI Housing Finance Limited, and such it was on the face of it without jurisdiction. Therefore, it is not the case of adjudication of disputed question of fact, but on the face of defense made out by the IDBI Home Finance Limited. Here, my lord, also they say that itself is appears that it had no subsisting valid mortgage in respect of the property in question, and thus it is the fit case for interference under Article 226 of the Constitution. If a writ petitioner, an owner of a property, alleges that notwithstanding the fact he or his predecessor never mortgaged the property in question, but in spite of such fact, a financial institution or bank has sought to exercise or has already exercised its power under section 13 of the Act, it is the duty of the writ court to ascertain the defense of such bank or financial institution in this regard, and if appears that on the face of the defense taken by it, there is no valid encumbrances created over the property in question at the instance of the writ petitioner or his predecessor, then the lawful owner in favor of the bank or financial institution to grant relief to the writ petitioner and to reject the defense of the bank or financial institution, and the writ petitioner has alternative remedy under such and such. In case of an unauthorized act not approved by the statute, which is apparent on the face of the defense taken, the alternative remedy is no bar in entertaining the writ application. The position, however, would be different if taking a loan from the bank or financial institution by mortgaging the property is admitted, but dispute is raised in regards to quantum of the amount payable. In those types of cases, the writ court should refuse to entertain. Here, my case, if they say, no, you have somehow given the property mortgage to me, I would have no case. I would not have say a single word. Now, section 14 order is also bad. It's an unreported judgment. Get a copy though. Paragraph page 29. Page 29. I'm sorry, we could not find that.
Yes, 29.
The second paragraph, the procedure laid down for sale as noted above under the Act of 2002 and rules of 2002 requires the secured creditor to sell an immovable property free from all encumbrances known to it or not. After sale, the secured creditor can no longer claim a security of interest over such immovable property, as such security interest stands dissolved by the issuance of sale certificate. On the execution and registration of deed of conveyance and title of the immovable property stands transferred to and vested with the purchaser, there remains nothing more to be done by the secured creditor in respect of such immovable property. The secured creditor does not retain any right, title, interest over the respect of immovable property sold under the Act of 2002. The contention that secured creditor still retains the right to obtain possession of the immovable property after execution of registration of the deed of conveyance in favor of power to it is misplaced. The transfer of immovable property by way of sale can be done by a deed of conveyance executed, stamped, registered under the registration
Yes,
act.
Mr. Nag, I've seen it.
So these are the points. So first, the taking cue from the division bench judgment, they say this is mine, not my property, is and doing that. It was the duty of the purchaser or bank or whosoever to file a suit for partition and ascertain which property belongs to him. And thereafter, section 14. That's what the first point I formulated before your lordship. That section 14 is an administrative action.
How can the writ court give you back possession?
If
you are now wanting
if something is per se illegal on the face of the respondent,
it has to be ascertained, Mr. Nag. You don't get my point. It has to be ascertained physically whether your property has actually been taken or different property has been
I understand what is following.
That remains.
The question
Otherwise, you may have a very good point.
Lordship is saying the status quo ante. I am saying
not status quo ante even. It has to be physically ascertained that your property has been taken and not a different property.
I say
who will do that?
I say,
has the mechanism to do
I
that.
say that kindly stop the clock when the action taken. If the action lordship has
sounds very good.
No, lordship has to take. If the action taken by the authority is bad in law or not. Now, if on the basis of these two judgments
is bad,
that
adjudication is dependent, Mr. Nag, on the other adjudication
I say
that they have actually taken your property. They are denying. They are saying we have taken a different property. So the premise is being challenged by them. They say that the property and deed of conveyance you referred in a notice is distinct from the secured asset and not the same property. And they say we have taken possession of the secured asset, which they say is a different property. So it has to be ascertained whether, because these are undemarcated garage spaces.
Correct. So that's why,
If it's undemarcated, the question remains.
That's why I go back to the first point. A secured asset, my lord, why?
Now you have to go before a civil court, place these facts, and get recovery of possession by establishing that this is
My
your
lord,
property.
it sounds nice, my lord, but in reality, my lord,
This does not sound
my lord,
nice.
my-
But this is the only record.
my writ petition
What you
was-
submit sounds nice, but
my
cannot be
lord,
done.
the petitioner before your lordship is 83 years old.
Now I know, but the law
She
cannot
will
be
die
changed.
even he gets an order of declaration, my lord. And here, my lord, all I am saying
With
before you,
utmost respect, Mr. Nag, she may not face the shock if she gets an order from a writ court.
my lord, I am saying, my lord, two things, my lord. First, my lord, the property, my lord, first point of law, the property has to be well defined. If it is not well
Points of law are very good. All the points of law are very valid points. No doubt on that.
so, my lord, if then the action is illegal, my lord,
They are not admitting that they have taken your property. They are saying we have taken a different property. How do you propose to go about it to ascertain whether your property has been taken or a different property has been? For that, that it has to be ascertained by the deeds.
That is the case of the borrower also. My lord, sees the borrower.
You don't get my point. Think over what I said. I'll come back in 10.
Lordship. Now, my lord, two things I want to show to your lordship. My lord, kindly take page 89 once. The complaint of the purchaser to the police. Now, my lord, also lordship sees page 89, lordship will find first paragraph, the measurement of the property is different. It is 148 square feet. Second, my lord, important that subsequently
measurement is different from your property's measurement.
Yes.
Not the secured asset measurement.
No, my property is 139.
Yes.
So you cannot say 149, you can take possession of 139. You say 148, you have to take possession of 148. Then, my lord, one is important. My lord, the date when commenced, my lord, sale when concluded. 30/11 is the sale notice. 1/12 is the 2021 is the sale. So thereafter, lordship kindly take page 109. When is the order? So it is of 2021 when my lord sale was concluded. And my lord kindly takes 109. When is the DM's order? My lord, the DM's order lordship will find on 7/12/2022. So on this code only, my lord, the section 14 order goes. And my lord, if section 14 order goes, my lord, I get back my position. On the simple score, order itself is bad in view of law decided by this court. That is one. Number two, my lord, it has to be demarcated. Well, my lordship seen. Well, now 140 it is admitted. Lordship, kindly look at the schedule of my property again. Well, lordship sees my property schedule is 161, 139 square feet, which I have. Well,
148 square bank was 148.
and even bank is also saying 148 square feet. Well, now, well, this is going to be a civil chaos. Well, they say it's a different property, and they will come and take my property, and I have to go back to civil suit and continue a suit. Well, when everything is different, and well, the order, the DM order, and apropos, well, the subsequent take up position is illegal on the basis of the law decided. So I rest my here. Well, if I say, set the clock when the illegalities are there. Well, if the illegalities are arrested, I am automatically get the subsequent the consequential orders. Now, here it is illegal on 3 counts. First is the property, secured property is not well defined, and second, the section 14 order is bad. Now, they also tactfully lordship has seen. They are also not giving me any documents. 109. They are even RTI application I have done 97. I don't have the DM order. They are suppressing it because they know they have committed a illegality.
DM order, you could obtain a certificate. You have the date.
No, how can I? How
have
can
the date, you have the property.
No. They are saying the different date. They are saying 148. I have 139. So how can I?
The names of the borrower and the bank and you have the
They
date
are
of the
supposed
order.
to keep it because they are asserting they are doing illegally.
Get a certificate. That's not an issue.
Lordship.
The other points remain.
Lordship. So that is my case before you, Lordship.
Yes. What do you say, Chennai?
There are two aspects to this. The first is that there is a sale that has taken place and that there is a section 14 order passed by the district magistrate. The second leg of my learned friend's argument is that there is an admission which is made by me, the bank, saying that the property which has been taken possession of pursuant to the section 14 order is not the same property. So I'll address the first legal argument. With respect to the sale having been vitiated because the notice is not in accordance with the rules, or that the section 14 order is a nullity because it has been passed post the sale, are points that they are bound to take before the section 17 court, which is the DRT.
Is it not a jurisdictional error palpably?
Because the section
we have the dates of both the sale as well as the section 14.
Because otherwise that would render section 17 nugatory. Otherwise, that would render the section 17 court nugatory because the section 17 court is only required to look into the procedural propriety of a section 13 proceeding. So today, if your lordship in writ jurisdiction decides that this procedure that has been adopted is, let us give full credence to their case. Hypothetical, of course, without admitting. Even if I give them full credence to their case, if today there is a procedural infirmity, that would have to be addressed before a section 17 court. And that's the law which has been said. There's a judgment which I'm carrying, my lord. 2010-8 Supreme Court cases. This is Satyavati Tondon. My lord, clearly, I'm sure my learned friend would be aware of this judgment, my lord. That the remedy against a section 14 order would be under section 17. As much as a remedy against a section 13 order would be, or a section 13 step would be under section 17. I'll place, if I'll just canvass, then I'll place reliance upon the judgment. That's the first leg of my argument.
Yes.
So in case the section 14 order is in the future declared to be bad, then the stop automatically gets set to the beginning. But that the writ court will not decide today, because there is an alternative and efficacious remedy that is existing. That's the first leg. With respect to the fact that they said that there is an admitted position that I have taken pursuant to this communication that my learned friend relies upon, dated 23rd of August 2023, which my learned friend has placed reliance upon, page 109. There in that document, like rightly pointed by your lordship, in that document, I am not admitting to the fact that there is no security interest, which was practically what his argument was. I am saying that there is a security interest. There is a mortgage that has happened. Therefore, I'm enforcing my security interest. But with respect to apropos the particulars that you have given in your letter, I am saying that this could be a distinct property. And with respect to this, I say that the reason I've said this is only because the measurement of the property is different. So that could also be a wrong assertion taken by my friend. Even though I've looked up the gift deed, there the measurement of the property is the same as what my learned friend submits. But this question would then not be decided by a section 17 court. This would necessarily have to be decided by in a civil suit. And prior to the order, prior to the decree pass, there would have to be an investigation carried out under Order 26. Without there being a proper commission with respect to the ascertainment of what is the portion of his property and what is the portion of the property which forms the subject matter of the security interest, the writ court cannot enter into the fact finding of this. So palpably, or at least prima facie, he cannot show that based on this assertion or this, there is no admission on this page, the page number 109. There is no such. I'm saying that there is a security interest. I've enforced that security interest, pursuant to which there's a sale that has been effected. Even if I assume that the sale has taken, for argument's sake, even if I assume that the sale has taken place prior to the section 14 order being passed, there is a section 14 order being passed. And according to my assertion, the fact that I assert before this court, there is the property which is the subject matter of the security interest that has been taken. He comes forward before this court and asserts a contrary fact. Now, if your lordship is to decide based on which portion of the property is taken, that would invariably mean that the writ court is entering into fact finding. For that, there would have to necessarily be evidence taken on record. There would have not even evidence. First, there have to be a report filed by an advocate commissioner saying that I have demarcated based on the deeds which have been produced by both the parties. Based on this, I'm saying that this property belongs to X and this property belongs to Y. So without that,
regarding section 14, possession having been taken about 1 year after the sale, regarding that, your only argument is that the section 17 is the proper.
No, there's another argument that I'll place, my lord. In my understanding of the law, and I could be completely, but you will test it. Slightly interesting. In my understanding, an order passed under section 14 could possibly follow the sale. So if your lordship takes up section 14 once, for this, my lord, I'll have to possibly distinguish the judgment placed by my learned friend, passed by Justice Bosha. That would it's a coordinate bench judgment. So number one, it does not it's not binding upon your lordship in the sense.
Right.
In
Unless
the sense,
I refer it.
Unless your lordship refers it, in my understanding, that would not be the correct.
Prompt me to refer.
Lordship looks at section 14 once. Chief Metropolitan Magistrate or District Magistrate to assist secured creditors in taking possession of secured asset. Where the possession of any secured assets is required to be taken by the secured creditor. So this is the first bit of the section. Or if any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of this act, the secured creditor may, for the purpose of taking possession or control of any of such, file an application. So there are two distinct facts given, two distinct situations given. The first is where there is a requirement for the possession to be taken, and there is a or, so they could possibly function alternately. The second wing of the section is that where it's required to be sold. Even if I take that portion of the section to be true, then sale is not the only requirement. It could also be transferred. Now that transfer could also take place in favor of the auction purchaser. I am not claiming any right. The judgment that my learned friend relies upon, passed by the coordinate bench, that goes on the premise that there is an assertion of a title upon the property by the secured creditor. So the learned single judge goes on to hold that after the sale has taken place, there cannot be an assertion of title by the secured creditor, because once that registration, in fact, now the laws changed. In fact, it's stronger. Now it says that once that sale certificate has been issued, there is no requirement for an execution of a registered deed of indenture by the secured creditor. But then I am not asserting a right The bank is not asserting a right. The bank,
Does the bank have locus standi even to take out in section 14 application? Because you are nobody regarding
for the purpose of taking possession in order to transfer it to the secured, in order to transfer it to the purchaser, auction purchaser.
Section 14 cannot confer title on somebody.
I am not asking for it.
So if you don't have title, where is the locus standi for you to take out a section 14 application? Who are you vis-a-vis the property?
The person
That is the premise of Justice Bosak's order.
The purpose,
which I find absolutely valid. I mean,
no, I'm not denying
unless
it.
you satisfy me.
I'm not denying it. I'm saying that if I have been the seller of the property, because pursuant to the section 13.2 and 13.4 orders, I've taken possession of the property, I'm selling it.
Once you sell the property, you are no longer, I mean, you are not the title holder of the property.
I'm not even claiming to be, but I can be a facilitator who gives the possession to the auction purchaser. I can definitely be. I'm not claiming right, title, and interest over the property. I'm not saying that I'm the bona fide owner.
You are acting on behalf of the purchaser.
Yes. And this section 14, section 14 under the SABYASACHI Act is the only provision under which physical possession of a property is taken. Now, this provision can only be invoked by the secured creditor, who at one point was the secured creditor. I'm not claiming to be the owner. So any assertion which is made by my learned friend which says that I'm claiming to be the lawful owner of the property, that is absolutely incorrect.
Cite Satu Tandon.
But irrespective, before I cite that, I'll take your lordship, I'll place para 42. But before I take your lordship through that, my assertion would be that irrespective, today, even if I assume for argument's sake that there is an infirmity, even that infirmity would have to be challenged before a section 17 court. Lordship will kindly take up internal page 123 of the judgment, my lord. Paragraph 40, it's a citation. That's it. Lordship kindly takes up paragraph 42. Yes. I'll read, my lord. There is another reason why the impugned order should be set aside if respondent number 1 had any tangible grievance against the notice issued under section 13.4 or action taken under section 14. Then she should have availed remedy by filing an application under section 17.1. The expression any person, which your lordship has dealt in several orders passed by your lordship, para 42, sir. Any person used in section 17.1 is a wide import. It takes within its fold not only the borrower, but also the guarantor or any other person who may be affected by the action taken under section 13.4 or section 14. Both the tribunal and the appellate authority are empowered to pass interim orders under section 17 and 18 and are required to decide the matters within a fixed time schedule. It is thus evident that the remedies available to an aggrieved person under the SABYASACHI Act are both expeditious and effective. So therefore, section 17, like your lordship is already aware of, because section 17 does not apply only to the borrower or the guarantor, to any aggrieved person. So today, the fact that the physical possession has been taken, if I go back and I connect the dots, their cause of action is that the physical possession of the property has been taken. The physical possession of the property has been taken by an officer which is sent by the district magistrate of the district along with the assistance of the police. So that is their cause of action. So if they're aggrieved by that particular action, they come squarely within the fold of an aggrieved person under section 17. Because that is the step that they've taken. And also they've challenged the sale. The sale also is amenable to jurisdiction under section 17. So this writ otherwise, my lord, is not maintainable. This has to go before the DRT.
No, my lord, just, my lord, I was, my lord, wanted this chance, my lord, to address, my lord, the issue of Shottobati tendon. My lord, he has placed reliance on 42. Now, my lord, division bench judgment is absolutely correct because this is a bench strength true judgment. My lord, Shottobati tendon, this judgment was passed on the basis of a constitutional bench judgment. And that is, my lord, a 5-bench bench, my lord.
Justice Bosak's judgment was a division bench judgment?
No. The, my lord, justice.
So the other judgment is...
Now, my lord, kindly take paragraph 47 once, on the basis of which this law was formulated in Shottobati tendon. Now, my lord, kindly paragraph 47 once. My lord, what? My lord, the constitutional bench has said, well, it's very interesting, my lord. I don't know, I want to test it. My lord, kindly takes the paragraph on the basis of which, my lord, the division bench, the bench strength true, my lord, formulated that point. My lord, ordinarily, it's in the middle, placidum E. Lordship says, ordinarily, the court will not entertain a petition for writ petition under Article 226, where the court will not entertain a where the petitioner has an alternative remedy, which, without being unduly onerous, provides an equally efficacious remedy. Now, my lord, when passing this judgment, this onerous portion has been, my lord, excluded. My lord, in my lord, the 42, lordship will find efficacious alternative remedy and stops here. Now, my lord, if, my lord, here I want to argue that, my lord, if I am a person who is no way connected to a proceeding, then whether I have to follow again this onerous process where I have to pay stamp duty and everything, and I have to go back to section 7. But this onerous condition was omitted or not looked into while passing this judgment of Satyavati Tandon. So the division bench judgment which I submitted before your lordship is on the proposition that it becomes onerous on the part of a litigant who is nowhere connected with this. And if, my lord, I would have understood, my lord, if I had any connection with this secured property, then, my lord, the question, okay, I have to go. But I have no way. As a matter of fact, very interestingly, I am thankful to my junior. 109 of the letter says that their deed, which they are referring to, is, my lord, a letter deed. Lordship says, page 109. Lordship says, the second paragraph, 1 parking space, 148, such and such, bearing deed of conveyance 5560 for the year 2001. And my gift deed,
gift deed is the 7. The original title is of 1990.
original title deed is of 1998. I have a prior right.
Even from my date of my deed, I'm 9.
So, my lord, I raised my submission on the basis, my lord.
Interest to 9. Admittedly, there is not a security interest. So I'm not challenging a security interest.
And my lord, my property can't be, my lord, on the admission of the bank is not security interest. So I don't come under the 4 corners of, my lord, section 7.
He's enforcing a security interest.
So onerous and security interest on the basis of which, my lord, I distinguish Satyavati Tandon. My lord, this is my submission. I'm grateful.
I'll close arguments on this. Good argument by both sides.
I'm grateful.
Hearing is concluded. Judgment is reserved in the matter.
Deeply obliged.
আচ্ছা পাঠিয়ে দিও আর এটা বইটা ফেরত দিয়ে দাও প্লিজ টেক ব্যাক দ্য বুক ইওর বুক এই সার্ভিসে একটা উইথ রুলস তোমাকে পাঠিয়ে দেবে এর সঙ্গে রুলস আছে এতে হ্যাঁ আর রুলস আছে
Item 14. This is my application.
Yes.
I'm for the respondent, my lord. Respondent 2 and 3.
Respondent 2?
2 and 3. Right. Insurance. Kindly come to page 39. Your
What's the
lordship.
affidavit of service? What about service on 1?
Yes, yes. Service was effected was within my advocate on records brief.
Yes, what is your grievance?
Page 39, my lord, kindly see, my lord, your lordship's order first.
Yes.
This is a claim of my insurance. Fire took place. Affidavit service quota.
I'm appearing for the respondent bank. I got confused between 14 and 16.
My lord, this is my affidavit.
Respondent bank.
Yes.
Right.
Bank is that corporate
Very
agent, my lord.
Yes.
Now, my lord, after this order, before the passing of this order, my lord, kindly
place the order.
My lord, lordship's order, my lord, page 40. Starts from 39, page 40. Accordingly, WPA number such and such is disposed of by directing the respondent numbers 2 and 3, that is the Oriental Insurance Company Limited and its manager, to ensure that the claim of the petitioners for the amount of insurance be processed at the earliest and a decision be taken therein in accordance with law, preferably within a 4 weeks from
Seen
date.
it. Yes. Then what happened?
My lord, prior to that, my lord, kindly come to once page 26. This is important. Why? My lord? Thereafter, I am going to the impugned order. Page 26, my lord, is the report of the fire brigade after the fire broke up.
Page 26.
Page, I do actually. তুমি দাঁড়িয়ে
26 is this.
No. My lord, maybe that's
Mine is 28.
it's my para. এটা তো 26 আছে। P4 my lord, আচ্ছা।
Information as yes, original.
Now, my lord, after your lordship's order, kindly see the order passed by the insurance company, page, my lord, 41.
Your lordship will find 43.
41 is my order. Oh.
Yes, 43. Your lordship will find
41 is in my page, my
Letting
lord.
is mismatching, my lord, 43.
43.
Let him move the matter for you, then you will answer.
My lord.
Yes, page 43.
My lord.
Repudiated.
Repudiated, kindly see the reason. After 4 days of the incident, you have lodged a written complaint to Katwali PS about the incident.
Written intimation. Not complaint, written intimation.
Lodge a written intimation, my lord, about the incident. Local shopkeepers who do not know anything about the fire in this shop. After the fire, you took some burnt garments in your own car and threw those into Kongshaboti River and took some burnt garments to your house, which is quite ridiculous. After opening few bills at your house, some kerosene smell found. My lord, the fire brigade report does not corroborate with the findings of the insurance. Fire took place at my shop. The inquiry somewhere else without giving any opportunity hearing of me. Even my lord, do not bother to look after the actual damage. My lord, they passed this order. My lord, my claim has been refused. My lord, I am challenging this.
Yes, what do you say?
Yeah. No, this is absolutely disputed question of fact. Because
What disputed question?
Yes, yes, my lord. May I?
Your
I-
report, the fire
Yes.
brigade report?
Yes, no. That is defined, my lord. First, my lord, kindly come to page 5. Page 5. Their pleadings. Page 5, para 7. Page 5, para 7. Their own averments, my lord. Incident happened on 9 September 2022. And my lord, the petitioner lodged GD on 13 September 2022 after getting the report from the fire brigade authority. That is the main contention, that before that, on 9th, the incident happened. What prompted you not to lodge GD with the local PS? When you received your favorable order from the fire brigade authority, then you go to the local police station and lodged intimation. In fact, after intimation to my client insurance company sent its insurance surveyor to inspect the property and their findings. The insurance investigator on the basis of the investigation report, this findings insurance company has no there was were there in the incident place of shops, but the insurance investigator was there. And on the basis of the survey report, the insurance company repudiated its claim. It's a pure question, disputed question of fact. It could, I think, it could be very.
These are no grounds at all. Your grounds. You're for the bank. How are you affected?
The prayers, my lord. This is against the section 13(2) notice, and my lord, again,
Yes,
because
yes.
bank has taken, my lord, surface action. My lord, when the last, this is the second round of litigation, my lord, when.
এটা হলো আপনার পরের ম্যাটারটা।
এটা 16
এটা 16 14 চলছে। 14 চলছে।
Well, I got confused. I was 16 and the same matter was being.
Yes, yes.
I got confused. I'm so
এটা
sorry.
16
Yes.
Yes.
These are no grounds at all. Because you have relied on an investigation report.
Yes.
These must be the contents of your investigation report.
Yes,
These are frivolous grounds. You have to pay the claim.
No, without asserting the actual claim and the assessment,
Well, claim cannot be, insurance claim cannot be granted in this way, insurance claim.
Very well be granted.
No, no,
Right now.
kindly.
To give you a demonstration how it is granted.
No, I shall file affidavit in opposition,
Learned counsel for the respondent insurance company seeks to file an affidavit in opposition, full stop. However, comma, in view of the primary materials relied on by the parties being annexed to the writ petition, comma, such prayer is refused. Full stop. Next para. The grievance of the petitioner is that
I am
despite a-
preliminary objection on the
this will be the first ground in your appeal.
Alternative remedy,
Full stop. Next para. Learned counsel for the grievance of the petitioner is that the petitioner that a fire broke out. It was your what factory shop?
My lord, shop.
Fire broke out at the shop of the petitioner, upon which an insurance claim was made. Full stop. On an earlier occasion, comma, despite the claim of the petitioner, comma, the same was not being processed by the insurance company, for which an order was obtained by the petitioner from the writ court directing the insurance company to process the claim. Full stop. Next para. However, comma, thereafter, comma, despite the Paschim Medinipur division of the West Bengal Fire and Emergency Service having given a report which palpably substantiates that fire broke out in the petitioner's ground floor garment shop on the relevant date, comma, the insurance company has repudiated such claim on frivolous grounds. Full stop. Next para. Learned counsel appearing for the insurance company submits that the what alternative remedy before which forum?
Because it's a money claim, my lord. It's a money claim.
Learned counsel for the insurance company submits that the petitioner has made a money claim, comma, for which the appropriate remedy of the petitioner lies before the civil court, puts up in view of such availability of equally efficacious alternative remedy, comma, the writ petition ought to be dismissed, full stop. It is further submitted that disputed questions of fact which are involved in the matter cannot be entered into by the writ court by taking evidence. Full stop. Next para. A perusal of the report dated September 13, 2020, authored by the divisional fire officer of the Paschim Medinipur division of the West Bengal Fire and Emergency Service, comma, annexed at page 28 of the writ petition, comma, indicates that as per the said report, comma, fire broke out in a ground floor garment shop of two-storied building containing ladies' garments. Full stop. Most of the garments, comma, according to the report, comma, were badly damaged due to heat and water. Full stop. Next para. As such, comma, the fire service authorities, comma, who are a disinterested party, comma, in a contemporaneous report with the incident, comma, clearly disclosed that a fire had actually broken out in the petitioner's shop on the relevant date. Full stop. Next para. In the impugned repudiation dated August 28, 2023, also annexed to the writ petition at page 43, comma, the insurance company, comma, apparently relying on an investigation report by an internal investigator of the insurance company, comma, refused to honor the claim of the petitioner on the following grounds. It page 43 থেকে 1 থেকে 4 এটা full stop. Next para. A bare perusal of the said grounds clearly shows that the same are patently frivolous and flimsy. Full stop. The first ground, comma, for example, comma, is that the petitioner had lodged an intimation to the concerned police station after 4 days of the incident. Full stop. Nothing hinges on such delay of 4 days insofar as the insurance claim is concerned, comma, nor does the said minuscule delay per se vitiate the allegation of the petitioner that a fire had actually taken place on the relevant date. Push up. The second ground is that local shopkeepers did not know anything about the fire in the shop, comma, which is a palpable misstatement of the insurance company, comma, apparently based on the investigation, apparently based on the investigation report, comma, since the report of the fire services authorities itself clearly vindicates the stand of the petitioner in that regard. Push up next para. The third and fourth grounds of refusal are not only uh, flimsy but border on the ridiculous. Push up. The third ground is that after the fire broke out, comma, the petitioner took some burnt garments in his car and threw those into the Kongshabodi river and took some burnt garments to his house, which according to the insurance company is within double inverted quite ridiculous. Double inverted close, full stop. The fourth ground is more absurd, comma, being that after opening few bales, BALES, at the petitioner's house, comma, some kerosene smell was found. Full stop. Next para. Such grounds are not tenable for a valid refusal of the insurance claim of the petitioner. Full stop. Next para. First, comma, there is nothing to indicate any foul play, comma, as the allegation of the insurance company that kerosene smell was found from the bales which were at the petitioner's house was much after the date of the incident and could not have any bearing on the fire. Push up. Read as a whole, comma, the grounds of repudiation by the insurance company are absurd. Push up. Next para. Hence, comma, the said grounds of repudiation cannot be sustained. Full stop. However, comma, since as rightly pointed out by the respondents, comma, the writ court cannot assess the actual amount of damage, comma, it ought to be it ought to be the insurance company ought to be given a second chance to assess the actual amount payable to the petitioner on the basis of the loss suffered by the petitioner. Push up. Next para. Hence, comma, WPA 22596 of 2023 is allowed, comma, thereby setting aside the repudiation dated August 28, 2023 by the insurance company of the petitioner's claim for insurance. Push up. The insurance company shall, comma, upon assessing the loss actually suffered by the petitioner by giving an opportunity to the petitioner to produce relevant documents and other materials to substantiate such loss, comma, decide on the quantum of compensation stroke insurance claim payable to the petitioner on the basis of the insurance policy of the petitioner. Push up. Next para. For such purpose, comma, the insurance company shall give an opportunity to the petitioner to produce relevant documents and give a personal hearing to the petitioner within 3 weeks from date. Full stop. Next para. Thereafter, comma, the insurance company shall proceed to assess the loss in terms of the above direction within 3 weeks thereafter. Full stop. After the expiry of the above mentioned 6 weeks, comma, the insurance company shall immediately take steps to disburse the amount of claim which, according to the assessment of the insurance company, the petitioner is entitled to under the concerned policy. Push up, no arrest cost against them.
Lordship, just 16, item number 16 is the similar, only khali back.
Let it be called on. 15 yes.
Item 15.
I'm for the petitioner.
Yes.
But I'm not pressing this application.
Then a counsel for the petitioner submits that the petitioner does not want to press the writ petition. Accordingly, WPA 23119 of 2023 is dismissed for non-prosecution without any order as to cost. Key. A written instruction in that regard filed by learned counsel for the petitioner today be kept on. 16.
16.
16.
My application.
You're for the insurance company.
No.
I'm for the bank here, Lord.
You're
The insurance company, no claim, but there is
affidavit of sale.
My lord, their prayer is
Mayor.
against the bank.
No, nothing. My lord, very short matter, my lord. This is the consequence of my lord, of the refusal of the my lord insurance company to my claim.
The same claim.
No.
Same claim.
No. Otherwise, my lord, this is a bank issue a SABYASACHI proceedings against me, my lord. After fire has been broken up, I am failed to pay. My lord, I have already taken a resource, my lord, before the DRT, my lord. This is the file number, my lord. Diary number is my lord, 906 of
What have you
2020.
challenged here?
Nothing is here, my lord. I am submitting this, my lord, disposed before there. Nothing is there. In this matter,
What's
nothing.
your prayer, I mean? Nothing in this. Should I dismiss it?
My lord, prayer was quashing the 13-2 notice, my lord, and the reply which was given under 13-3. My lord, this was the prayer in this writ petition.
Why, my lord?
When was the notice given?
My lord, notice was given, my lord, before the earlier round of writ petition, my lord. That was not brought into light, my lord. Notice was given
1 minute. When did the fire break out?
Fire broke out, কবে হয়েছে দেখো।
9th September 2022.
9 September.
9 September 22.
My lord. They are the my lord, corporate broker, my lord, the bank.
When did you give the 13-2 notice?
24th 7 2023.
Much subsequent to the fire.
My lord.
Otherwise, I would have smelled the kerosene again. I would have
No.
Yes, because if after their notice you did
lord,
this,
that is
then
my
the
somebody-
kerosene would have been valid.
Because, my lord, my earlier, my lord, I am also.
So you want to go before the tribunal? Should I dismiss this with that liberty?
And with that, my lord, already
My lord,
we have
13
preferred,
court
my
has already been issued, my lord.
My
This
lord,
was not annexed.
not
They
to
have.
take any coercive action. my
Learned
lord.
counsel for the bank at the outset points out that the writ petition ought not to be entertained since the petitioner has challenged proceedings in respect of which the bank has already taken measures under section 13 within bracket 4 of the SABYASACHI Act. Full stop. There is substance in such contention. Full stop. Accordingly, in view of availability of an equally efficacious alternative remedy, WP 824011 of 2023 is dismissed as not maintainable with liberty to the petitioner to approach with the same cause of action before the appropriate tribunal. No rest to cause urgency.
I'm grateful to you. Lordship, I beg pardon for the earlier matter.
Yes.
17.
Mr. Singh, you're for the state.
For the state,
Yes.
but I have difficulty, my lord, because
I-
there is a claim of petitioner is about 46 lakhs. So I asked the person concerned, the restaurant number 5. So today I got the number from him only. I spoke to him. He
That is
got to
unfortunate.
send a report.
State
The number of your officer, the phone number of your officer. What did you get from him?
He used to pay. So
Long
my
pending,
state
my lord.
report, whatever lordship passes the order there, but I have not.
Election matter, my lord.
What is the matter?
Matter is that, my lord, I was, my lord, served as a contractor, my lord, regarding, my lord, 2021 election, my lord.
When did you make the claim?
Claim, my lord, my lord, claim, my lord.
10th of May 2020.
Yes, my lord.
Any reply to this?
No, my lord, no. I made representation before the authority regarding my claim, my lord, but no reply, my lord. On dated, my lord, 3rd of August 2023, my lord.
Mr. Singh, if you have not repudiated the claim,
My lord, I already have spoken to
Well, I
the person concerned.
What
Yes, a report is ready. He's sending the report, my lord, tomorrow by 10 o'clock, my lord. Keep it at 2 p.m.
report means saying what? That
Work order has been issued,
No,
my
no,
lord, and my
he's
lord,
not-
disputing the quantum.
No, he is not in a position because he's an election ward. They, I mean, taken over 5 to 7 schools for putting up these police staff.
No, he
So
has
there
made
was
a
no
claim.
telephone, no electricity, no, according to the petition, fan and light. So his client has been engaged. There was a tender being float. My London client's tender was the lowest. So he was being given.
He did the work. There is no doubt on that.
But I do not know.
Report,
now.
you will file report on what?
He says that the police authority, the claim is pending before the DG office. He has not released the claim, but they are going to.
they are official.
I'll dispose of the writ petition, direct them to pay.
Yes, my lord.
If you are not disputing the amount of
No.
Yes, my lord.
He can use it.
the claim of the petitioner is innocuous. Full stop. The petitioner, the petitioner did several electrical works for the respondent authorities during an election and raised
2021.
bills accordingly. Full stop. However, comma, despite the petitioner having made claims for the due amounts, comma, lastly on May 10, 2021, comma, the respondent authorities are sitting tight over the issue. Full stop. Next para. Learned counsel appearing for the respondents, comma, although not controverting the claim, controverting the quantum of the claim on merits, comma, submits that there have been certain impediments, certain official impediments in disbursing the amount to the petitioner, who shall be that as it may, comma, since the claim has not been disputed on principle, comma, WPA 24166 of 2023 is allowed on contest, is allowed, comma, thereby directing which respondent should pay you.
My lord,
Executive engineer, my lord.
Who is to disburse, Mr. Singh?
my lord, actually,
Respondent number 5.
Five.
5 and 6, my lord.
but now the
That's the
respondent 5 says it is lying with the DG office because the
That is
police
the
officer-
official, my lord, propaganda. my lord.
DG office means which
The office
respondent?
means district magistrate, I think. If you kindly pass the order.
Directing, thereby directing the respondent number 5 to disburse the amounts due to the petitioner in terms of the petitioner's claim annexed at page 17 of the writ petition to the petitioner at the earliest, comma, positively within 6 weeks from date. Pushed up. Next para. Respondent number 3 is directed to ensure that the funds for such payment being made to the petitioner are released to the respondent number 5 for such disbursal to the petitioner as expeditiously as possible, comma, positively within within 3 weeks from the date of communication of this order to the respondent number 3.
Well,
Everything
instead-
taken care of, please.
instead of 3 weeks, my lord, make it 4 weeks, my lord. Well, I will-
District magistrate will 4.
4 weeks,
আচ্ছা
my lord.
3
I will-
যেখানে
I will
বললাম
ask-
3টা শুধু 4 হবে, 3 weeks টা 4 weeks হবে, 3 weeks becomes 4 weeks, but that 6 weeks remains. Thank
I will.
Thank you very much, Mr.
Much.
Next.
18.
Petitioner.
My application, my lord, I was also praying, my lord, few days, my lord, 2 days to come up with a supplementary affidavit.
Then
There
it
are
goes
two
down,
documents.
no upgrade.
So kindly, my lord.
No upgrade matters, no time.
There are 2 documents. I'll be very candid. I drafted this. I went to my senior. I've been severely admonished for not bringing
Learned
them on
counsel
record.
for the petitioner seeks an adjournment to file a supplementary affidavit. Pushed up. However, comma, in view of such adjournment being sought, comma, the matter cannot retain its position under the upgraded matters list.
So she will not
Pushed
record
up.
that kindly. my lord.
Accordingly, let the matter stand adjourned till when?
So if that's the case, my lord, I'll be in.
Which date? Give me a date.
I was only praying for your lordship to keep it on Monday. I'll come up with a supplementary affidavit,
Adjourned
serve and
till
come back.
Monday, that is December 4, 2023, when it will be listed under the regular heading. Next.
May I proceed, your lordship, only not record that it goes, my lord.
Item
I'll not be able to-
19.
I'm deeply.
Yes.
Your Lordship, Mr. Shomu Mujumdar is appearing in the matter. He's leading me due to some personal difficulty. He
Goes
couldn't-
down.
Your Lordship, please.
Then you
there's
start the
some-
matter.
Your Lordship, there's
Upgrade
some
matter, no
urgency.
time.
Only not today, Your
You
Lordship.
cannot block upgrade matters.
I
list.
know. Your
I'm not
Lordship.
being able to add other matters as upgrade matters. Then you start the matter. I have no difficulty.
Your Lordship, kindly, just for one day.
No.
One day.
An adjournment is sought by the petitioner, Fushab. In view of such adjournment, comma, the matter shall now be listed tomorrow under the regular heading and not under the heading upgraded matters.
Lordship, there's some urgency, Your Lordship, because Lordship,
Upgrade matters, no time.
This matter, my lord, one of the similar matter was dismissed by my lord, my lord. There was
no, the facts are different here. Your Lordship.
Yes, next.
Item 20.
Yes, sir.
Item 20, my lord, I am for the petitioner. Last occasion, my lord has
Service.
heard me, my lord, service.
All served.
All served.
What is the matter?
My lord, I took a cash credit loan. Thereafter, my lord, the bank has issued 13-2. My lord, challenging that.
What is this?
My
Yes, handing over some order.
lord, I'll tell you, your lordship, my lord, what has happened, my lord. I took a cash credit loan. Thereafter, my lord, I could not pay. Then bank issued 13 4. Thereafter, my lord, there was an one-time settlement offer from my end that they did not consider. I filed an application under SARFAESI Act before the tribunal, and that is pending before the DRT 3, and DRT 3 is not in, I'm sorry, DRT 2. DRT 2 is not in session, my lord. Now, my lord,
Siliguri bench has been given that power.
yes. My lord, not yet.
Yes. 1 or 2 days back. Take instruction, come back tomorrow.
And my lord, while pendency of my writ petition, they have issued 13-4. My lord, in the self same matter, my lord, I got this order, my lord. That's why I handed up that particular order. And on the last occasion, my lord, there was nobody.
No,
on the side of the,
in the writ petition, you have challenged 13-2.
No, 13-4. I'm sorry, 13-2. Then, my lord, 13-4 was issued subsequently.
So if they have only given you a 13-4 notice, then there is no scope of any interim.
My application before the tribunal is not getting heard.
You have a remedy. You can go before the appellate tribunal and seek for a transfer before some other bench. That power is also there in the SARFAESI Act.
My lord has passed that order, my lord.
No. Learned counsel for the petitioner submits that the petitioner challenged an action, a notice under section 13 within bracket 2 of the SARFAESI Act issued by the respondent bank, whose during pendency of the writ petition, however, a measure has been taken by the bank under section 13(4) of the said Act. It is submitted that the concerned bench, that is the second bench of the Kolkata Debts Recovery Tribunal, where the petitioner's application under section 17 of the SARFAESI Act is pending, has not been functional during the relevant period. Next para. Accordingly, the petitioner seeks a limited protection till the petitioner can move the application under section 17. Yes. Next para. However, in the opinion of the court, since the measure under section 13 within bracket 4 has been taken only recently during pendency of the writ petition, no interim measures are required to be, no interim protection is required to be given to the petitioner at this juncture, particularly since the petitioner's application under section 17 is already pending. Insofar as the non-functioning of the concerned bench is concerned, the petitioner is always at liberty to approach the appellate tribunal for seeking a reassignment before an operational bench. Accordingly, WPA 24373 of 2023 is disposed of by granting liberty to the petitioner to approach the Debts Recovery Appellate Tribunal with a prayer for assignment of the petitioner's application under section 17 of the SARFAESI Act to some other bench than the bench where it is now pending for the purpose of early disposal of the same. If such a prayer is made in writing in appropriate format by the petitioner before the DRAT within a week from now, the DRAT shall decide the same as expeditiously as possible, preferably within a week thereafter, and reassign the matter to some other functional bench. No orders to cause.
11th of December is the, kindly see the notice.
I've given you a fortnight. Yes. Do that immediately. Within a week you have to apply. That will be done within a week. Next.
21.
My lord, I am appearing for the petitioner.
My lord, Mr. Kaushik Gupta will be appearing for the petitioner online.
Move the matter.
My lord, I am appearing for the petitioner, my lord. My lord, your lordship can hear me, my lord?
Mr. Gupta, please unmute yourself.
Yes, I am unmuted, my lord.
Yes, what is the matter?
Yes, my lord, the petitioner is an Indian citizen, a lady who intends to marry a foreign national. Now, taking such steps, we have made an application before the appropriate authorities under the Special Marriage Act. Now, at the time of filling up the form, it came to our notice that in the website of the government of West Bengal, the Aadhaar card of both the parties are required as a mandatory requirement. My lord, kindly comes to page 44 of your lordship's brief.
He is a national of which country, Mr. Gupta?
United Kingdom.
Page 40?
Or 44.
44, right. 44, yes.
Yes, my lord, see is
that their Aadhaar card is mandatory. There is a star next to the Aadhaar card.
Without the Chandabindu, Mr. Gupta. Aadhaar is without the Chandabindu.
Yes, my lord. The Aadhaar card is
A Freudian slip, but even then, yes. Aadhaar card
is made mandatory. My lord, there is a star next to Aadhaar number.
You want a relaxation on this?
Yes, my lord. A citizen of UK cannot have an Aadhaar card.
Mr. Gupta, something equivalent can be produced by you.
My lord, whatever the passport is there, there is no social security number in UK. We have submitted the passport.
Yes.
My lord, I have taken the instruction from the authority. My lord, already we have upgraded the marriage portal.
Oh,
This
achha.
is my instruction.
Now Aadhaar card is not necessary.
The order passed by this honorable court dated 9th August 2023 in
Achha.
Ruma Datta alias Ruma Roy. We have already upgraded the marriage portal.
So now the Aadhaar card is not necessary.
Not necessary.
Oh,
She can apply, he or she can apply by uploading the passport.
passport. Very good. Fair.
My lord, kindly record this submission so that
I'll keep the document on. She has handed over a document also.
my lord, my lord.
Counsel for the petitioner contends that the petitioner, being an Indian citizen, wants to marry a national of the United Kingdom, however, since there is a mandatory requirement to produce the Aadhaar card of both the proposed spouses, the proposed husband of the petitioner cannot produce such document, and as such, the marriage is being hampered. Next para, learned counsel for the respondent authorities hands over a communication along with dated September 11, 2023, along with a written instruction indicating that the concerned website stroke portal has already been upgraded to do away with the mandatory requirement of production of an Aadhaar card. It is submitted that a foreign national can, produce a copy of the passport for the purpose of getting married under the Special Marriage Act. Appreciating such fair stand of the respondent authorities, the cause of action espoused by the petitioner no longer remains germane. Next para, accordingly, WPA 24449 of 2023 is disposed of by granting liberty to the petitioner to apply for getting married on the concerned web portal by production of the passport of the of her proposed spouse and the other relevant documents which are so necessary. No order is to cause urgent certificate.
If we can receive a copy of the written instruction.
Can you give a copy? Yes.
Grateful, my lord.
Thank you. একটা line আরেকটা add করে দেবেন. A copy of the documents handed over in court today is also handed over to the learned advocate for the petitioner by his counterpart appearing for the respondent. Thank you.
Grateful, my lord. Grateful.
22. 22? Yes. Mr. Mitra, you are for the petitioner.
For number 7, I have a point of maintainability. It's up to my lord whether or not you want to hear that. It's a 5 minutes.
Mr. Choudhury, my lord, and for the petitioner, he's here.
What is the maintainability issue?
Well, here they have challenged the communication of the competent authority under the Apartment Ownership Act. That communication was pursuant to an order in a civil court of our division bench for conducting elections by special officer, a member of the bar. Special officer was told to consult the competent authority under the Apartment Ownership Act. He consulted, and the competent authority gave him whatever his views. And well, the election, it is ultimately for the special officer to accept, not to accept. That is the order of the court. So special officers, so this is not a competent authority acting under the statute. It is
that communication has been challenged here.
Yes. That communication. Because it is like asking the special officer to take assistance of BLRO in demarcating. If BLRO gives some communication,
so it's not binding also.
Not binding. Just sees the division bench order of our High Court. এটা কোন পাতায় বলতো? That is Page 160, it starts regarding the holding of an election of an association. Page 174. No, can't be 170. 174. No. 180. 180. কোন জায়গাটা বলতো? Oh, this is the earlier order. No, not in this order. You can give me 1 minute. You can give me 1 minute.
Too many cooks, Mr. Mitra.
Yes, Lordship, page 248.
240, yes.
I should best follow my flags. That is that's the shortest page 241. 241 is the order.
241, yes.
At 247, bottom. At 247, last six lines. While we accept the finding of the learned trial judge that there should be a free and fair election, however, we are of the view that under the facts of the case, the special officer appointed by the learned trial court, with the aid of the competent authority, shall hold the election. The special officer, in consultation with the competent authority, shall prepare the electoral roll and decide on the mode of voting. So that consultation is the communication which has gone to the special officer. That is so that is what they have challenged.
And where is the report?
The
impugned report of the special officer.
Page 276. 276.
Yes, 276.
276. With respect to the above mentioned. Second time, in this context, I would like to inform you that I had received the interim report of the special officer on 19th September. In terms of the report, I had already communicated to the special officer by a letter dated 21st September, which was sent by post.
This has been challenged by them. Fair. Let me hear them. Yes, Mr.
The subject matter of challenge in the writ petition is a order or a letter of the competent authority. That's all. Now I take it a writ lies against the competent authority. So whether it is on merits or not, that's a different issue. So maintainability, I haven't been able to appreciate. I was trying to understand. Its order is the impugned subject matter impugned before your lordship is the order which my lord just saw. Now, before I come to that, why? But in just 2 minutes, I'll give your lordship the background. This pertains to a building project called Elita Garden Vista, which is, my lord, in Newtown. One of the prime issues, and my lord, the reason why the writ petitioners are before your lordship is there is a disputed tower. Why we say it's a disputed tower? Because, my lord, there under the West Bengal Apartment Ownership Act, a Form A has to be filed, whereby, my lord, all the allocations, lordship is aware, my lord, we have done. Yes. We have been canvassing these points in other matters also. The number of towers which can come up are already specified. The common areas are demarcated. And my lord, not only the number of towers, the flat area, the garage area, everything is demarcated and it's a registered document. Lordship will remember, well, this is under the West Bengal Apartment Ownership Act. Now, my lord, this Elita Garden Vista project, my lordship will find EGV stands for Elita Garden Vista. But it was first conceived by a Singapore-based promoter called Keppel Magas. Then, my lord, subsequently, the Singapore promoters were unable to work over here. Whatever be the reason, they left. Then, my lord, the Indian parties, my lord, joined that. And then, my lord, the project conceived of 15 towers only. 15 towers. We are really concerned with the 16th tower, which was brought in subsequently and which is not there in Form A. And the 16th tower is referred to as the 8th tower. Why 8th tower, my lord? I'll indicate. When the original promoters, my lord, had conceived the 15 towers, they had omitted in numbering tower number 8 because of Feng Shui reasons. My lord, in 8 is perhaps perceived not many lifts, lordship will find, doesn't have 13th floor. It has 12A and then 14. So now 8 tower, it is there. So, my lord, at the end of the day, we are concerned with the 16th tower.
So originally there were 14 towers.
Form 15 towers. So Form A,
it was not there.
Originally 15 towers, numbered as 1 to 16.
After 16, right.
1 to 16.
Very.
Tower 8 was not there. And Form A, as it stands even today, doesn't show the existence of such tower.
Yes.
Now, my lord, there are other proceedings I am not referring to as of now. What has been shown to your lordship, to cut a long story short, my lord, when elections were being held, a particular group of the promoters purporting to represent the association filed a collusive suit. In that, a special officer was to be appointed and, my lord, elections were supposed to be held. Then, my lord, in that suit, my lord, in diverse interlocutory orders, it came up before this High Court. Kindly come to, my lord, page 180. My lord, it's a longish order which starts at page 160, but I'll straight away come to page 180. They had initially obtained an order to hold elections under the aegis of a special officer. We come up, my lord, the association comes up in challenge. And, my lord, this is the order of 17th March 2023. Lord, the entire history will be there, my lord. Kindly see page 160. Lordship will find applicants are the owners of Tower 8. My lord, this is, my lord, in an application which was made by the flat owners of the 8th tower. Elita Garden Vista, hereinafter referred to as Elita. Well, in that, kindly come to straight away page 180. Internal page.
Chaudhary, what Mr. Mitra probably meant was that this is pursuant to this communication was pursuant to this.
I'm coming to
You say it is not only in pursuance of that.
No, my lord, my main grievance in the writ petition is the competent authority, the jurisdiction the competent authority was supposed to exercise was not exercised by it. We want the competent authority to give the hearing and exercise.
So you say it was Dehor's this?
Yes. No, but they did not call anybody. He didn't even say whether it is in Form A they are owners or not. They say every flat owner is owner. That was not the mandate. Milord, I'll tell your lordship what the mandate was. Milord, when an issue arose, Milord, on one hand, the owners of Tower 8 came and said, look, we have deeds. We have deeds with us, therefore we are owners. We say if the Tower 8 entirety is illegal, deeds or no deeds, it doesn't matter. So, if it is not reflected in Form A, how can you, whether you can be in the voters list or not? That was, my lord, the issue. So, my lord, the division bench said that, all right, I am appointing a court-appointed special officer. Initially, my lord, Tower 8 was...
So that this matter cannot be taken, completed this side of the recess. After recess, I have two Jalpaiguri matters. Tomorrow? I think it's better to keep it tomorrow because today there is some uncertainty. 3 p.m.
Yes, yes,
3:30
yes.
is there also.
Tomorrow.
So, after order record, although the hearing is commenced, the same cannot be concluded.
May I file the affidavit of service, my lord, I have also, my lord,
Due to
kindly
paucity
give
of
me
time.
leave to file a supplementary affidavit. A wrong annexure was given. I have given the correct annexure.
Tomorrow, second half, I have some personal reasons I will not be in court.
Full
So
stop.
first.
Next para, affidavit of service filed today be kept on record. Full stop. On the prayer of learned counsel for the petitioner, leave is granted to file a supplementary affidavit, which is also kept on record. Full stop.
A copy of
At the outset, comma, an objection as to maintainability of the writ petition is taken by learned senior counsel appearing for the respondents.
Number 7. Well,
Full stop.
not
Be
all,
that
but Mr. Shah has
respond number. You're for respond number.
numbers.
Number such and such. Full stop. Be that as it may, comma, the matter shall be placed fairly at the top of the list under the same heading tomorrow for hearing. এই অরিত্র
Number 3. Number 3.
ওটা 3 হবে নাম্বার 3 ওটা তুমি ইয়ে করবে কালকে আপগ্রেড ম্যাটারই থাকবে কিন্তু একটু উপর দিকে চলে যাবে টপ না আপগ্রেড হেডিং এর উপরে
ও অত্যন্ত সুরেখ
Jalpaiguri matter, extension of interim order. Item number 1.
Lord, I appear for the petitioner. Lord, I need to inform your lordships about one thing. I filed this writ petition in the circuit. But a point was taken when the motion was moved that the property relating to which it is filed situated in Dakshin Dinajpur. Justice Shampa Datta Pal, my lord, entertained past an interim order till today and will return the file to be taken up by the principal bench. So today it is being taken up, my lord, in the circuit list. So this I need to inform your lordships, but I have issued them a notice.
Circuit is going on there.
Circuit is going on, but kindly see the last order. It as per Justice Dattapal's order, the property falls within the jurisdiction of the principal bench. Now the circuit bench only has jurisdiction over 4 districts.
Acha, right.
So it is in Dakshin Dinajpur. So may kindly see the order, Miller, for a second.
Mentioned as Darjeeling in your writ petition?
That was not because
wrong.
Because an order of Siliguri DRT was challenged. That is why it was mentioned Darjeeling. Siliguri DRT is situated within the jurisdiction of Darjeeling district. But the property falls within the jurisdiction of Dakshin Dinajpur.
That order.
Our ladyship's not observation. Kindly come to the 10th October order for a
Yes, let
second.
me see that.
আচ্ছা is in item 1 the order was passed by Siliguri DRT. That is within Darjeeling's district.
You were right, apparently. I mean, you have challenged an order of the
Yes, but you know, the court has observed this, you know, and I bow down. I bow down to court, and court has not favored me with an interim order. Now, you know, the difficulty.
Naturally, you will bow down.
Always, I have to bow down always, Milord.
Particularly if an order is passed.
99% in my case it is rejected. So, Milord, I have to bow down always. It's not that Milord allowed.
Satisfy me first why this should come within the 1%. Considering
No,
the repetition is transmitted. What is the challenge? You have challenged a particular order.
I have challenged a particular order and the notice of the Siliguri bench that was passed without giving
Very
me
well.
notice.
Let us.
My lord, if my lord
have you
feels
given
that-
a notice to the other side?
I have given a
Yes, my
notice.
lordship.
You are appearing for the other side? Yes.
Yes, I'm appearing for the respondent number 1 and 2 for the State Bank of India.
Right.
So that was my second point of concern. I gave them a notice that it will be mentioned today. I'm grateful to my learned friends, they are appearing today. But what happened, I tell you, lordships.
No, Mr. Chakraborty, tell me something. The Siliguri was performing as in charge of Kolkata.
No. After the formation of the Siliguri DRT, the file was transmitted from Kolkata to Siliguri because the property is within the jurisdiction of South Dinajpur district.
South Dinajpur falls within Siliguri DRT.
But not within Siliguri circuit.
No.
It's yet to be added.
Yes.
Perhaps after the constitution of the new building, it will be done.
Very well.
Now,
Very well. Let us. Yes.
Now,
you want an extension of interim order?
Yes. Today, my lord may extend the interim order, and my lord may,
Yes, I'm extending for a limited period and putting it for hearing.
My lordship, before extension of the interim order, I make two submissions before your lordship.
Yes.
Number 1, DRT Siliguri within the jurisdiction of the circuit bench Siliguri. They
Right.
are challenging the order of the recovery officer of the debt recovery tribunal. But in the writ petition, they make the party of the receiver, but they do not make the party of the recovery officer of the debt recovery tribunal.
Need not. He's the judge. The judge needs to be the party.
If the order was challenged, there is an appellate provision. If anybody is dissatisfied, they can prefer an appeal before the recovery to the presiding officer DRT Siliguri. If they dissatisfied, they can go to the appellate side. But they do not make the party and make the receiver as a party in this regard. And the order was challenged within the jurisdiction of the circuit bench Jalpaiguri. And this writ petition cannot be maintainable because there is an appellate provision, there is alternative remedy.
Right.
So that is my submission. And if the courts allow us to file the affidavit in opposition, how this writ is not maintainable.
Very well. I'll extend for a limited period, direct you to file opposition and record your submission as to maintainability.
Yes,
Learned
deeply.
counsel for the respondent submits that the recovery officer was erroneously not impleaded as a party to the writ petition. Subsequently, comma, a jurisdictional question is raised insofar as, comma, according to learned counsel for the respondent bank, comma, the Dana. An equally efficacious alternative remedy is available in the form of an appeal before the debts recovery appellate tribunal. Push up next para, keeping the question of maintainability open, comma, the respondents are directed to file their affidavit in opposition within what time would you take for that affidavit?
Within 2 weeks.
Within fortnight from date, push up reply if any shall be filed within a week thereafter. The matter shall be listed in the monthly list of January 2023 for hearing. The interim order is extended till February 15, 2024 or until further order, whichever is earlier.
Deeply.
Thank you.
Deeply.
Part heard matter, item 2 and 3.
Yes.
My lord, first of all, my lord, all on a sudden it has come. So I will be praying for an adjournment. And apart from that, my lord, kindly see, my lord, whether the formalities as enumerated in the rules has been complied with.
That matter?
Yes. Whether formalities in the rules has been complied with.
Mr. Basu, when should I take it up? Give me a short date.
Can my lord take up this matter?
Why do you say
My
that?
lord, there is a paraphernalia has to be complied with because this is a circuit bench matter.
Yes.
If on the circuit bench it is on,
could be assigned.
Yes, my lord, it has to be no, even if part heard, it has to be, my lord, rule 4-5. কোথায় গেল? 5টা দেখা? It has to be applied before the runner register. Register will place before the Honorable Chief Justice. If permit, then Lordship can take up.
Well, I'll give you liberty right to the Chief Justice. I'll fix it.
I do not know whether because it is being taken up by other coordinate bench also. Justice Basu, Justice Gangopadhyay, all of the circuit bench matter are being taken up.
Mr. Basu was not there before
Kindly
their
see
lordships.
5C.
Mr. Basu was not there before their lordships to take the point. That's
Justice Basu. Justice Basu.
5C kindly read. 4 has been, my lord, amended. In all cases where the bench is, circuit is not in session, can be moved. But C exception, if the parties in any case which has been instituted in the circuit bench requires the register of the circuit bench in writing for such case to be heard in the principal bench and the Chief Justice agrees to such request, the said case shall then be heard by the principal bench.
this can be overridden. This does not apply. I'll hold that. Come back tomorrow.
Tomorrow, give me some time.
What time?
All on a sudden today.
It was being heard there.
Being heard long back.
Yes, get prepared today, tonight.
Give me weekend at least.
Learned Senior Counsel appearing for the respondent submits that in view of Rule 5 within bracket small c of the Calcutta High Court within bracket Circuit Bench at Jalpaiguri bracket close rules, comma 2019, comma.
My lord has already held that he has required to be Chief Justice consent. Kindly see your lordship's order, last order.
A request is
Probably
to be made.
in your lordship's mind, this circular was there. The rules
A
were there.
request is to be made before the Honorable the Chief Justice for the matter to be taken up by the principal bench. Full stop, next para. It is also pointed out that in the order dated September 21, 2023, comma, it was observed by this court that the next date would be notified to the parties subject to obtaining consent from the Honorable the Chief Justice and shall be taken up before the principal. This is also there.
Yes, it is lordship's mind.
It's
You are
very well.
not wrong.
Accordingly, comma, for the sake of propriety, comma, the matter is adjourned till December 4, 2023. Full stop. The petitioner, the learned advocate on record for the petitioner is requested to take the consent of the Honorable Chief Justice, Honorable the Chief Justice through his secretary for the matter to be taken up by this bench, comma, being a part-heard matter of this bench, comma, in the meantime. Please write this evening. Just write it to the Secretary of the Chief Justice. I don't think consent will be with him. I've indicated that it has also been made part-heard. You also indicate in your letter.
That will appear on 4th or 5th.
4th.
The combined list will be published.
Oh, acha, 5th. December 5th.
5th, I am awfully busy.
6th. December 6th.
All matters in fixed. At 2, well, not
December 6th at 2 p.m. At 2 p.m.
Great.
No.
Appellate side matter. Item 23.
Lord, this is my repetition. It was taken.
LOC.
Yes, my
Yes.
lord. I
Bank.
the bank is madam.
Request.
My lord,
Request for the
should-
request.
Yes, my lord.
No, LOC,
It
my
will
lord.
be- This is in a sealed cover, my lord.
Must be the usual, Mr. Mishra.
No, my lord. Basically, this is not usual, my
follow,
lord. This is some extraordinary case, my lord. And
Ms. Alam, please take your seat. They cannot give it to you.
Your
Yes, I
lordship
direct.
will have-
I have also not seen it sealed in.
No, as per you, sir, the government circular.
Yes.
Precious nothing, Mr. Mishra.
My lord, basically, my lord, I'll tell my lord. This is I'm aware of your lordship's last judgments, my lord.
Not my judgment only, several high
I have seen that.
Yes.
But there is some difference, my lord. This LOC was issued in the year 2019, my lord.
Right.
And my lord, there was some direction from the CBI, my lord. May I hand it over, my lord?
That has to be a part of your request.
My lord, there was, my lord, in 18, my lord, it was directed that all the bank officers should instruct. They were duty bound to issue.
Mr. Mishra, LOC has to be issued only on your request.
Only on my request, my lord. But in case of a fraud, my lord, I was duty bound to do this. And my lord, this was a case of a fraud, my lord.
Then it had to be reflected in the request. Nothing in the
My lord,
request.
I have not gone through that, my lord, technically, my lord. But
go through it. Need not go through it technically. You may go through it otherwise also. Find out one sentence. The petitioner can also see it because the left-hand column is predominant.
the reasons for opening of LOC, my lord.
What is that?
Promoter and guarantor of an NPA account.
No such case.
My lord, my lord, my lord. My lord, it was only indicated that they were the promoter and guarantor of a.
Only that.
That was there, my lord. But actually, the reasons for there's reasons, my lord. Reasons for submitting this, my lord. Details, my lord. I have handed over, my lord. One,
There are also two things in
my
addition.
lord. One.
No, let them finish this.
ठीक है,
Yes,
ठीक है.
Mr. Mishra.
I
My
don't
lord,
have to say.
whether I've got DHM.
What?
My lord, one letter.
This CBI.
Yes, my lord. My lord, this was issued in the year, my lord, 2018, my lord. It's specifically 24/9 to 18, my lord. My lord, if your lordship comes in the second page, my lord. And my lord, just once early warning signals prescribed by the RBI, copy enclosed, my lord. I'll show what was the term. Are observed, the bank should be on alert regarding some wrongdoings in a loan account which may ultimately turn out to be fraudulent. It was fraudulent, and the petitioners are arrested by my lord in CBI. My lord, they are still under custody. Just 3-4 days back, my lord. They were arrested in this case, my lord. And banks need to reduce the time gap between the occurrence of the fraudulent act of and the declaration of and the second paragraph says, my lord, it is proposed that an appropriate officer of the bank is empowered to request for opening of LOC against the economic offenders, my lord. That was a recommendation from the CBI, and after that, my lord, one notification came, my lord, in which the banks were empowered to make a request for such in case there was a fraud, my lord. Banks were duty bound. Maybe the wordings were only indicative, my lord, that they were NOC, but reasons for that was that the account was has gone into fraud. And my lord, there was one office memorandum in 2021 also, my lord, which, my lord, may I? কপি আমার কাছে নেই, একটাই ছিল। আমাকে এই জাস্ট হোয়াটসঅ্যাপে পাঠালো, আমি প্রিন্ট আউট নিয়ে আসছি। And I'm sorry for the printouts, my lord, because it is.
How does this help you, Mr.
My lord, my lord, the CBI says, my lord, that I was duty bound to do to make a request for LOC in case of a fraud account, my lord, and I was empowered to do so accordingly. That recommendation which was, my lord, as a Ministry of Home Affairs has allowed me to make a request if there is any case of fraud account. Had it been the case that only it was a recovery case, my lord, I cannot use that as a tool for recovery. That I understand, my lord. I have gone through your lordship's previous judgments also on that effect, my lord. But, my lord, if your lordship comes to page number 29, mark 29, my lord, para 6.
Yes.
My lord, this was basically, my lord, lordship was correct, my lord, that it was only on my request and approval it should be done, my lord. My lord, para 6 says, my lord, the existing guidelines of the regarding the request of LOC in respect of the Indian citizens, foreigners have been reviewed by the ministry after due deliberation in consultation of the various stakeholders and in supersession of the exciting guidelines issued by the Ministry of Letters. OM referred in paragraph number 1. It has to be decided with the approval of the competent authority. And who was the competent authority which has been given, my lord? Is the chairman of the bank.
The account has been declared as fraud.
Yes, ma'am.
Under which circular? RBI circular?
Yes, ma'am. It is still, it has been declared in the fraud, my lord, in the 2020, my lord. For that, I may have to, and at that point of time, my lord, this due to this circular, my lord, due to this circular, my lord, in 2009, the recommendation was done, my lord, and it has already been declared as a fraud, and case has also been registered, my lord. And my lord, there was a paper publication.
When the request was issued, it was not a fraud. Not
my lord, it was suspected fraud, my lord. Kindly see the exactly notification. If there is suspected fraud, to avoid the suspicion, my lord, this has to be given, my lord. And based on that and the subsequent office memorandum, it was, my lord, there are further office memorandums in 2004 and 4th October 2018, my lord. There are two. I don't have the extra copies, my lord. It was given, my lord, and the printout is also not good, my lord. But in the 2018, my lord, I was, according to these office memorandum, I was duty bound to do so, my lord. And subsequently, it was declared as a fraud. And my lord, though it's a paper publication, I should not produce, my lord. But
paper publication. What does the paper publication say?
My lord, just 2-3 days back, they were all arrested in a CBI case in the same.
This person. I mean, the petitioner.
Yes. My lord, if your lordship can.
No, definitely not.
My lord, it's only a fact which I'm submitting based on some. This is not. And that was the reason the LOC was. And if your lordship so desires, my lord, I can. All the documents I can place.
No, keep these on record.
No, my lord. When it was fraud and declared.
No, subsequent things I want.
That was.
I'll record that you have submitted that in 2021. It was the account was classified.
My lord, perhaps 20, my lord, subject to.
After this request.
After request. But at the date of the
you had suspected.
He was, my lord. It was subsequent. Bank has the account had gone into NPA, and it was suspected it was a fraud. And ultimately, after few months, my lord, only after 2-3 months, it was in 19 it was issued and it was declared also, my lord. And every time, my lord, in each quarter, my lord, perhaps they have to renew this request from the bank side, my lord, that LOC should remain or not remain. Since it was declared as a fraud, so it was again requested that it is. Bank has intimated the MHA department saying that there was
only one LOC has been issued. The LOC
impugned here. 2019, my lord.
Right. Good.
And this was my submission regarding to the submission of LOC, my lord. My learned friend.
This is the only submission which you can make. Yes, they have challenged LOC. And Ms. Alam, the usual submissions.
Yes.
Mr. Mishra is responsible. Yes. Good. Yes, petitioner. Please take your seats. Yes.
After this, my lord, your lordship has seen what he's basically saying is that, my lord, there was a declaration of fraud in 2020, which is after. My lord, today that declaration is not there. Your lordship has already passed an order, my lord, setting aside that fraudulent declaration in this matter only. So that is there. So, my lord, I have just called for that order, the same. And that is not there. Without hearing nothing, my lord, it was done. My lord, most importantly, my lord, the account, my lord, was revised in April 2019. There was a revised sanction in April 2019, which is at page 32. So they revised my sanction limit and everything and granted me this. Then, my lord, within a few months in December, they stopped me. And then I write to them that what happened, why are you stopping me? Now, my lord, kindly see their response of 6th March 2020, page 70. This is for the first time what they say. Page 70. This is the reason given to me.
Yes.
It bears reference to your letter dated 21st February 2020, wherein you have informed that it has come to your knowledge that a lookout circular has been issued against you, while mentioning that you have your business arrangements abroad, hence you have requested the bank to withdraw the lookout circular. Swati Mining availed credit facilities from UCO Bank, Kolkata. You being the guarantor have executed security. I was not even a director, Milord, at that point of the company. Guarantee documents in favor of the bank. The above account has been classified as NPA on 30th June 2019. So, Milord, April 2019 revised sanction, 30th June, Milord, they have done an NPA. This also, Milord, without my knowledge, nothing behind my back, within 3 months. Consequent to which, bank has initiated recovery proceedings against the borrower company and on its promoters, director guarantee. Milord, this is an incorrect statement. As on that date also, Milord, no recovery proceedings were pending. LOC, Milord, of course, cannot be issued, Milord, in lieu of recovery proceedings, but even on that date, nothing was pending. Please
Now
note,
they have initiated recovery proceeding.
recovery proceedings, Milord, subsequently OA in 2021 or in 2021. Subsequently, much later. Please note that lookout circular has been issued against you. No, the present outstanding balance is rupees such and such. Please note, lookout circular had been issued in due adherence with the instruction of Government of India. And Milord, before that, consequent to which bank has initiated recovery proceeding against the borrower and its promoters. And this is the outstanding. Now, this outstanding also today, Milord, we have cleared.
I'll not go into that.
Yes.
I'll not go
So,
into that.
Milord, as on the date your lordship has seen, Milord, there was no recovery.
Very good. Learned counsel, the present writ petition has been filed challenging a lookout circular issued against the petitioner. Push up next para. Learned counsel for the petitioner contends that although the in April 2019 there was a review.
Yes.
No,
Page
yeah,
30.
there was new sanction, my lord, fresh
Although,
sanction, my lord. But
although
ultimately it was found to be fraud and it was
although in the
declared as
month of April 2019, there was a review of the sanction limit and a fresh sanction was issued, allegedly on June 30, 2019, the account of the petitioner was marked as a non-performing asset within bracket NPA, and a request was made thereafter by the respondent bank for issuance of a lookout circular within bracket LOC, bracket close, full stop, pursuant to the said request, the impugned lookout circular has been issued, full stop. It is argued that none of the relevant yardsticks necessary for issuance of such an LOC have been satisfied in the present case. Full stop, next para. Learned counsel for the immigration authorities submits that the said authorities are duty bound under the government circulars, to issue a lookout circular if such a request is made by the bank, by the appropriate designated officer of the bank, which has been done in the present case. Who sub next para, learned counsel appearing for the respondent bank submits that at the relevant juncture, that is on November 19, 2019, when the request for issuance of LOC was made, the reason for opening of LOC was shown to be that the petitioner is a promoter and guarantor of an NPA account, which subsequently, it is submitted, the account of the petitioner has been marked as a fraud account under the concerned RBI master circular, master direction. Push up next para. Learned counsel for the bank places reliance on a communication to the secretary, Department of Financial Services, Ministry of Finance, Government of India, by the Joint Director of the Central Bureau of Investigation. Pushed up in the said communication, it was inter alia observed by the CBI by way of a suggestion that once early warning signals prescribed by RBI are observed, comma, banks should be on alert regarding some wrongdoings in the loan accounts, which may ultimately turn out to be fraudulent, full stop. Banks need to reduce the time gap between occurrence of fraudulent act and declaration of the same as fraud. Full stop. That apart, comma, it was suggested by the CBI that the appropriate officer of the bank is empowered to request for opening of LOCs against economic offender stroke defaulter, comma, at the same time when the account is being declared as fraud, full stop. Issuance of LOCs, comma, as per the said suggestion, comma, is governed by the OM dated October 27, 2010 of the Ministry of Home Affairs, which lists out the authorities empowered to so request. Full stop. In view of the above, comma, the CBI requested that the matter be taken up with the concerned authorities in the Ministry of Home Affairs to make appropriate changes in the OM dated October 27, 2010. Full stop. Next parallel. Counsel for the bank also places reliance on an office memorandum issued by the Deputy Director, comma, Department of Financial Services, comma, Ministry of Finance, comma, Government of India, dated October 4, 2018, where the grounds for issuance of LOC have been enumerated. Full stop. Next para. Learned counsel next cites an office memorandum, another office memorandum issued by the same ministry dated February 22, 2021 in support of his contentions. Full stop. Next para. The copy of the request for LOC handed over by learned counsel for the respondent bank today is opened and taken up for perusal by the court. Full stop. Next para. A consideration of the submissions of the parties leads us to the grounds of issuance of LOC, comma, which primarily remain unaltered. Full stop. Next para. In terms of the office memorandum dated October 4, 2018, comma, the only grounds which could be applicable in the present case vis-a-vis the bank are that if the departure of a person is detrimental to the sovereignty or security or integrity of India, or that the same is detrimental to the bilateral relations with any country, or to the strategic and stroke or economic interests of India, economic interests of India ta italic say, or if such person is allowed, to leave, comma, he may potentially ... in acts of terrorism or offenses against the state, and stroke or such departure ought not to be permitted in the italic say larger public interest at any given point of time. Full stop. Next para. Insofar as the request double inverted মধ্যে by the CBI to the Secretary, Department of Financial Services, comma, Ministry of Finance is concerned, comma, the same cannot be a binding rider for the bank to take resort to for the purpose of issuance of requests for LOC. Full stop. The only relevant consideration regarding issuance of LOC is the concerned office memoranda issued by the Government of India, full stop. The CBI, comma, being merely an investigating agency, comma, does not have any authority or jurisdiction under the law to enumerate the grounds for issuance of LOCs. Full stop. In any event, comma, the communication relied on by the bank is a mere suggestion to the concerned Ministry of the Government of India from the end of the CBI to bring in modifications in the office memoranda. Full stop. However, comma, the suggested riders were not specifically introduced even in the subsequent office memoranda issued by the Ministry of Home Affairs. Full stop. Next para. In any event, comma, irrespective of the suggestion of the CBI, comma, merely because proceedings are going on against a particular defaulter, comma, cannot be sufficient reason for resorting to the high action of interdicting the personal liberty of the person to leave the country by issuance of LOC. Push up next para. As far as the office memorandum dated October 4, 2018 is concerned, neither the request of the respondent bank nor the circumstances of the case justify a conclusion that if the petitioner left the country, the same would be detrimental to the economic interests of India or could not be permitted in larger public interest. First up, merely because the petitioner, according to the bank, is a defaulter, does not furnish sufficient justification for issuance of LOC. First up, it has been held time and again by this court and other courts, other high courts, that issuance of LOC cannot at any point of time be a substitute for recovery proceedings. Push up next para. Inasmuch as the declaration of fraud is concerned, learned counsel for the petitioner has submitted that the said declaration with regard to the petitioner, has been set aside by an order of this court.
And upheld by the division.
Vide order dated July 18, 2023, passed in WPA 16291 of 2023, as affirmed by the judgment and order dated November 16, 2023, passed by a division bench in MAT 1769 of 2023. Pushed up, even otherwise, supposing that a declaration of fraud was made under the concerned master direction against the petitioner, and the same would have survived till today, the same if ipso facto does not furnish sufficient ground for coming to the conclusion that the petitioner's departure from the country would affect the economic interests of India or the larger public interest of the country. Push up next para. The master directions in that regard issued by the RBI only pertain to issuance of warnings to other operators in the financial market regarding the credentials of a particular borrower stroke guarantor stroke director, and do not in any manner acquire such a high pedestal so as to be of importance in the larger public interest or the economic interests of India as a whole. Push up next para. The office memorandum dated February 22, 2021 does not make any major alteration to the grounds stipulated in the office memorandum dated October 4, 2018, which would be germane to the issue. Push up next para. It also has to be noted that, as the reason for opening of LOC, the bank had merely indicated that the petitioner is the promoter and guarantor of an NPA account, which by itself, is not a valid ground for issuance of LOC from any perspective whatsoever. Push up next para. In such view of the matter, the issuance of LOC on the basis of the invalid request of the bank, which does not satisfy the concerned office memorandum of the Government of India with regard to issuance of LOCs, cannot be sustained. Full stop. Accordingly, WPA 24924 of 2023 is allowed on contest, thereby setting aside the LOC issued against the petitioner and directing the respondent authorities to take immediate steps for communicating to all authorities, which were communicated about such issuance of LOC in the first place within 3 weeks from date, to ensure that the petitioner is not restrained on the basis of the said set aside LOC from leaving the country in any manner whatsoever. No rest to cause.
Affidavit of service.
প্রথমে লিখে নেবেন affidavit of service.
I am appealing for the customs response.
Right. 24.
For item number 24, my lord, I am the petitioner appearing in person.
Yes.
I am for the respondent.
Right. What is the matter, please? Mr. Dattu? Yes.
This is the matter of my lord seeking information under RTA Act in the form of inspection report. Eastern Railway denied the inspection report. So
What was the inspection report about?
the inspection report is a part of the inspection made by various railway authorities in a time frame, whatever the short for.
In respect of what?
These are the public works, my lord.
Inspection.
Inspection is called, that is a footplate inspection report. It's a part of inspection. So, my lord, the Eastern Railway Authority continuously denied, but the First Appellate Authority made the direction upon the public information officer to furnish the information within the 15 days. But since that, I didn't receive any information. So the matter went to, I filed a second appeal to the CIC, the Central Information Commissioner. The commissioner itself, now they are not upholding the previous order. Till date, we are not receiving any inspection report.
Where is that order of the First Appellate Authority initially directing them to give the information?
Page number 32. Page number annexure T2.
T2?
T2, 23 it is.
No. No, where is the direction of the Appellate Authority, First Appellate Authority, directing them to produce furnish the information to you?
Yes, it is 27, I think. It's not, the page number is not marked. Okay. 25. The last one, Lordship, decision.
Yes, why don't you provide the information? Provide the information.
My lord, my instruction is that the second appeal was rejected, man.
Oh, have you got a copy of that?
No, my lord. Not annexed.
Then you knew this matter would be taken up. On the last occasion you appeared,
yes,
he was directed to serve you a complete copy.
Yes.
This was taken up on 2 occasions. Why shouldn't you be ready with the order of the second appeal?
Second appeal before the. My lord, my instruction is always rejected. My lord, kindly.
Even if the second appellate authority, the second appeal is rejected.
Yes.
This order remains. This order remains. Page 25 order remains. That was the first appellate authority direction that you had to give report.
My lord, kindly come to the short list of dates which was filed by the petitioner.
Short list of date. Annexed to the writ petition?
Yes. Annexed to the writ petition. My lord, the petition
judgment passed by the Honorable CIC.
UI denied furnishing information to the petitioner. First appeal was filed.
You are relying on the last date?
No, my lord, the 28/11/2022 petitioner filed second appeal before the Honorable CIS.
You are relying on the last date, 29th of September, the judgment passed by Honorable CIC. Yes, what was the judgment passed by the CIC?
Actually, they rejected the plea. Actually, CIC is saying that the order passed by the public information officer is in order. So they will not intervene.
Where is that order?
In page number 27, my lord.
No, you are giving wrong page numbers. What are you saying? Check up properly. Neither of you are ready with the matter. Yes, you should point out several annexures are there. Why should I find out all the documents?
Yes, my lord. One by one, kindly come, my lord. Everything is there, my lord. My lord, kindly come to the first, my lord, page 22. And what is the original information they asked for?
Show the entire thing. Start from after page 25. Page 25, appellate authority directed you to furnish the information.
Yes.
After that, what happened in this second appeal?
That thereafter, my lord.
Why did he prefer a second appeal? This was in his favor.
Yes, my lord.
Why did you prefer the second appeal?
Lordship, in page 26,
And why did you prefer the second appeal? Yes,
because in page 26, the public information officer clearly stated that they will not furnish the information. Maybe
So that's a contravention of the order of the first
yes,
appellate authority. So why did you challenge the order of the first appellate authority?
No, that is my lord. The main thing is that first appellate authority directed the public information officer to furnish the information.
That was in your favor.
Yes.
But you preferred an appeal against
No,
that. And lost in that appeal also.
No, my lord. That is that the after furnishing of the first appellate authority order, the PIO vehemently denied that.
That is a violation of the first appellate authority. You should have pointed out to the first appellate authority. Anyway, yes, furnish the information.
My lord, that second appellate
Already,
authority rejected.
Second appellate authority rightly rejected,
Yes.
affirming the first appellate authority order which directed you to give the information to him.
May I
Approve and information remarks is furnished. 1 and 2 inspection note may.
Let's come to page 25, last paragraph.
Yes,
That is the
I am,
direction
my
of
lord,
the.
from 27, my lord.
Acha, 27, yes.
The Right to Information Act, DRM. The inspection note made by the official of an organization
No,
normally
you
relates to the
could not do
function.
this. This is in violation of the first appellate authority order.
But
Definitely.
my lord, according to them, my lord, the second appeal is rejected, my lord.
but my lord, please keep page number.
Ashunash at order. This is a comedy of errors. The prothom line. This is a comedy of errors. Full stop. The petitioner approached for certain information from the SPIO, which being refused, a first appeal was preferred before the appropriate authority under the Right to Information Act. Full stop. Although the first appellate authority specifically directed the
My lord, kindly
SPIO
come to the page
to
31
provide
and onwards, my lord.
to provide the information in question, comma, the same was refused to be given by the SPIO on the ground that inspection note made by officials of an organization normally relate to the functioning of the organization, which is a document meant for internal circulation within the organization and is exclusively for office use only. Full stop. Next para. Surprisingly, comma, the petitioner, instead of seeking implementation of the order of the first information authority upon the violation of the same by the above refusal dated August 25, 2022, within bracket annexure P5 at page 27, bracket closed, comma, preferred a second appeal before the appropriate authority, which was ultimately turned down on the ground that the order of the first appellate authority did not suffer from any illegality. Push up next para. The respondent authorities place reliance on the dismissal of the second appeal by the second appellate authority to submit that the petitioner cannot reiterate his claim for furnishing of the information in question. Push up next para. Although it is not clearly understood as to what prompted the petitioner to prefer a second appeal against the order of the first appellate authority, instead of seeking an implementation of the same, comma, the said action may be attributed to the fact that the petitioner has been litigating in person.
My lord, for a moment, my lord, kindly allow me to submit one thing, my lord.
After the matter is over, I am
No, no,
passing order.
not
Definitely
over.
not. Next para. Be that as
My
it
lord,
may,
regarding
comma.
this, my lord, page 22, my lord, I have not completed my submission, my lord, only one aspect, my lord.
What aspect?
My lord, page 22, actually, what information they asked for. My lord,
Whatever they asked for, that has been directed by the appellate authority to give.
But my lord, the second appeal authority rejected. My lord, why it was not ultimately, my lord, not furnished? Question of, my lord, the security and that commercial development and development aspect of the engineering division, my lord, in all respect of the railway, which maybe, my lord, there is a relation regarding the future tender process and, my lord, to improve the lacuna in the security measures, my lord. For this, my lord, if it will disclose, my lord, ultimately, my lord, the security aspect of the railway may hamper, or, my lord, somebody may be benefited for, my lord, for commercial purpose, because, my lord, this report is also involved regarding the future tender, my lord, for development.
Right.
And, my lord, for this is, my lord, kindly see the section 8, my lord.
Definitely not. No. Be that as it may, comma, the ultimate effect of the dismissal of the second appeal is that the order of the first appellate authority was affirmed. Full stop. The relevant portion of the first appellate authority apostrophe S order dated August 24, 2022 is quoted here in below. এইটা এই ডিসিশনটা ডিসিশন থেকে এই পর্যন্ত পেজ 25. Full stop. Next para. The crux of the said order is that the SPIO was directed to provide item-wise information as available on record with operating department within 15 days from receipt of the said order. Full stop. It is noteworthy that there is no qualification in the said order to the effect what information is required to be given. Full stop. The unqualified and unambiguous direction of the first appellate authority on the senior DOM and PIO, comma, Eastern Railway, comma, Shialda, was to provide item-wise information as available on record as sought by the petitioner. Full stop. Next para. The said order was only affirmed by the dismissal of the second appellate authority and, comma, as such, comma, the respondent authorities cannot resile from such position, comma, having not preferred any challenge to the said order of the first appellate authority. Full stop. The subsequent refusal dated August 25, 2022 by citing section 8 within bracket 1 within bracket small d and section 8 within bracket 1 within bracket small e of the RTI Act 2005 is palpably illegal and in gross contradiction of the order of the first appellate authority and cannot be sustained from any angle. Full stop. Next para. Although the respondents are now seeking to set up a new case by reopening the chapter and arguing that for the sake of protecting the secrecy with regard to future tenders and the functioning of the railways, comma, the said attempt on the part of the respondents is post facto. Post of the direction of the first appellate authority having attained finality, comma, the same cannot now be reopened by the respondent authorities who are bound by the said direction to furnish the information sought by the petitioner in its entirety. Full stop. Next para. In any event, comma, the information sought was regarding train number, comma, name of inspection authorities, comma, vehicle guidance of concerned trains from which inspections were made, comma, legible copies of permits issued by senior DOM stroke Shialda on behalf of employees working under unified SM cadre performing inspectorial job to conduct inspections, comma, etc., comma, which cannot have any vital bearing on the safety and security of any function of the railways. Full stop. In any event, comma, in view of the above observations, comma, the respondent authorities are bound by the order of the first appellate authority to give all the information to the petitioner. Full stop. Accordingly, WPA 25037 of 2023 is allowed on contest, comma, thereby directing the respond number 4, that is the senior divisional operation manager cum public information officer, comma, Shialda division, comma, Eastern Railway, to furnish the information sought by the petitioner in its entirety as per the direction dated August 24, 2022, issued by the first appellate authority within bracket annexure P4 at page 25 of the writ petition, bracket closed, positively within a fortnight from date. Full stop. The parties, comma, for the purpose of compliance, comma, shall act on a server copy of this order without insisting upon prior production of a certified copy. No address to cost.
Grateful, Your Lordship.
But এই প্রথমে একটা লাইন অ্যাড করে দিতে হবে মেঘনাথ, ওই leave is granted to the petitioner to move the matter in person.
25.
Yes, please. Yes. Mr. Banerjee, yes.
Yes, Lord, this is an application. Lord, for shifting, Lord, representation was made for shifting the transformer. Lord, that has been put inside my by the side of my house at page.
Mr. Manager, please take the microphone a bit closer. Transformer shifting.
Transformer shifting, page 20. Lord, representation, page 20, my lord, the photographs and lord, representation by the petitioner himself. Previously, my lord, by the power of attorney holder, but petitioner, lord himself, lord, made the representation at page 35. 35 be disposed of with this in order upon given our opportunity, whether it can be removable or not. Because
You're
I
asking
cannot,
only for that?
Yes, my lord, that is exactly.
I'll not record your appearance.
Yes, my lord.
I will not record your appearance.
Yes, my lord, I told Mr. Mr. Pine.
Yes, come.
Your appearance should also not be recorded, Mr. Pine. Your junior's appearance. Yes, what do you say? Consider?
Consider, but the first of all, but this writ petition is bad for the non-joinder of necessary party. Because the Kolkata Corporation is a necessary party. This
Learned Senior
Ma-
Counsel appearing for the petitioner submits that the limited grievance of the petitioner is that the grievance redressal officer of the CAC Limited, Chourangi Square, has not disposed of the representation given by the petitioner dated October 3, 2023, annexed at page 35 of the writ petition. Next para. Although learned counsel for the CAC Limited takes a point of non-joinder of the Kolkata Municipal Corporation as a necessary party,
because the inspection is necessary.
since inspection is, according to him, necessary by the said authority, the said objection is turned down, since the present grievance pertains only to the non-consideration of the representation of the petitioner by the GRO and does not seek any adjudication of the rights of the parties. Accordingly, WPA 25134 of 2023 is disposed of by directing the respondent number 3, that is the grievance redressal officer, CAC Limited, Chourangi Square, to decide the representation dated October 3, 2023, annexed at page 35 of the writ petition, given by the petitioner in accordance with law as expeditiously as possible, preferably within 6 weeks from date, upon giving adequate opportunity of hearing to all interested parties. No orders to cause urgency.
Deeply appreciated. And I have given an alternative site, Malan, which where the Malan name.
They'll consider the representation. Give all the names.
Yes, Malan.
Give all the names, all
Yes,
the
yes,
appearances,
Malan.
not only your appearance.
No, Malan.
Affidavit satisfactory. Yes. Next.
26.
My lord, this matter is relating to earnest money submitting during the bid tender procedure.
Yes.
Your petitioner challenged that earnest money should be submitted by all bidders from their own account, and that's also provide NIT. I am placing first. Kindly come to page 32. That B, payment procedure.
Yes.
B Roman II. The bidder will payment through RTGS. The bidder will print the challan and use the pre-filled information to make RTGS payment using his bank account.
No, this is B2.
Capital B payment procedure.
Yes.
Under that B, payment through RTGS.
Yes, right.
Then II.
Right. Yes. Print the challan and use the pre-filled information.
His bank account.
Yes. Using his bank. Right.
His bank account. And next, accounting and monitoring process under heading D. Next page.
Yes.
33.
Yes.
II3. That last line. And bidder's account as applicable by using user access as provided by the NIC. That is accounting procedure. And your petitioner raised objection according to NIT within 48 hours. And after opening the technical bit.
You have an objection to this?
That not verifying all bidders' account, whether that earnest money submitted from their own account or not. This
You are insisting upon this.
Yes. Kindly.
So where is the scope of writ petition?
Yes, my lord.
I mean, it's a part of the NIT. They have to do this.
Yes,
If
they are not following this. Yes.
How
Kindly
can you
come-
establish that? Yes, show me that.
Kindly come to page 118.
Yes.
That after my objection, this is intimated me in second paragraph.
Yes.
This is to inform you that there is no such clause for verifying of the bank account of EMD, earnest money, payment source in the instant NIET. You also did not submitted any obvious such and such document. Next line. This is not a common practice to check the bank account of participating bidders. So the matter may not be pursued further only due to your assumption as this state. This is by lot mostly public interest because once if within 48 hours no bidders challenge it, then nobody have any right to challenge it.
But you have not pleaded any specific violation. You say generally it has to be violated because if there is no verification,
I given some
instances
objection,
also.
yes, that against the other bidders.
You have implemented them also.
Them also and also bank also.
Very well. Let us hear them. Yes. What do you say?
What have fallen from your lordship, in addition to that, my lord, the petitioner participated in the proceeding. After being unsuccessful, he challenged the NIT.
No, he was unsuccessful. In this particular case, he is not challenging a clause. If he was challenging a clause, then after participation, his scope would be very limited. But he's saying the mode in which the tender has been processed. He's challenging that. He's saying if there is a clause, there are so many clauses saying that it has to come from the account of the bidder, which may have a justification because otherwise there will be cartelization, maybe. Now, if you don't verify the accounts, how can you know that? Then he's facing unfair competition.
No, my lord,
And others may be using the sourcing from other accounts and he's paying from his own account.
Lord, there is no documentary proof that whether the other bidders have submitted from not their account, Lord. That has not been provided to us. We have no scope to check that.
Then my lord, may I
No, there is no scope for anybody if you don't verify the accounts at the inception. He is saying that the modality in which the tender took place, if you can't verify, how can you insist that this is complied with? If this is the payment procedure as per your NIT, how can you say a particular bid is eligible if you don't have a mechanism for ascertaining this? That is what he is saying.
My lord, kindly have a look at our NIT, my lord, page 32, my lord.
I'm there.
My lord, payment mode B.
Yes, B.
A, subclause A, my lord, payment by the net banking, any listed bank to ICICI payment gateway. We have received the payments from this gateway, my lord. We have received all these payments, my lord, through
that has further riders.
Yes, my lord.
Such as BA2 that says II. Bidder will make the payment. Bidder will make the payment after entering his unique ID and password of the bank to process the transaction.
Yes.
Now, again, subclause B, BB.
BB2.
II says the bidder will print the challan and use the pre-filled information to make using his bank account. Now, you have to at least verify whether it is his bank account or not. And D also, D3 is also there. Bidders accounts.
And also affidavit there, page 64, that in this regard, affidavit also submitted by the all bidders. Page 64, affidavit X, item 3, undersigned would authorized and request any bank, person, firm or corporation to furnish pertinent information as deemed necessary and or requested by the department to verify his statement.
If you have no mechanism of verifying, how can you insist that how can you ascertain that this is followed?
My lord, kindly have a look at page annexure P9, my lord.
Page
131, my lord.
The last but one paragraph, my lord.
Yes.
With reference to your letter number, this objection raised by the petitioner's advocate, my lord. Letter nil, dated such and such, received by email or such and such. B Devolution Committee denies and dispute each and every allegation and continues made paragraph 4 to 8 and to say that the annexed documents are not obvious documents, evidence in your support. Your client has also submitted EMD challan receipt, debited account reference number such and such, this is from PNB, the Punjab National Bank, Raiganj, where the bank certificate is prescribed format in your favor, in your client from the IDBI arrangement. Lord, he has also submitted from another, not his.
That
From,
both account is my account, capital.
no, my lord. No, no, no.
Yes.
Why was he disqualified?
He was
That
disqualified.
technically,
Technical.
not financial.
And subsequently, my lord, he has been suspended. His release document become found to be
that is another,
illegal, my lord, but he has been suspended subsequently.
Not subsequently, my lord. That proceedings is
Mr. Mondal, only one thing, there was no discrimination. I mean, this was equal. For all the bidders, they were not verifying.
no, my
So,
lord.
how can you say that this is an essential clause of the NIT?
Because, my lord, suppose I am giving you an example.
Why should this be an essential clause?
Yes, I am giving.
Yes.
Suppose A has some money. A given X, Y, Z 3 for bidding. That coming from his account. X, Y, Z contested that bid. And they are selecting who will get that bid.
But Mr. Mondal, that could be obviated by somebody who wants to cartelize. A would be parking that amount in each of their accounts. And they'll be paying from their accounts. So that is not a valid.
Let them do that, because after failing, that amount returning direct to that the account of A. That's the thing.
No, Mr. Mondal, no interference.
So kindly, my humble request of a submission, my lord, that respondent number 2, engineer in chief may be verify this whether that thing happened or not. And take steps accordingly after giving hearing to me, because
you don't have a right after technical rejection.
No, my lord, this is my right, because I am showing here that kindly come to page 48. Page 43. Page 43. Para 24. That any objection that is within 48 hours. I given that.
Yes.
Objection.
They have dealt with that.
Yes.
No, they given answer that this is not practice. Kindly come to that.
They have dealt with your objection in their own way.
Oh, that not practice. That's mean they are not verifying this. This is the mandatory part of the.
No, Mr. Manoj. The petitioner participated in a particular tender process and turned out to be unsuccessful on technical grounds. Learned counsel for the petitioner challenges the modality in which the tender was held. It is submitted that in terms of eligibility criteria, as stipulated in clause B, capital B of the tender document.
Clause 2B.
Sorry, you are right. Clause 2, capital B of the tender document, comma, the bidder was to make payment after entering his unique ID and password to the bank of the bank to process the transaction, and to print the challan and use the pre-filled information to make RTGS/NEFT payment using the italic say his, so the his italic say bank account. Furthermore, comma, in clause 2, capital D, it was enumerated that the nodal officer of the finance department, comma, government of West Bengal will be able to view the department-wise EMD and tender fees deposited by the bidders to the pooling PLLING accounts and fund transferred downstream at various stages of the tender process to the government accounts and bidders accounts comma, as applicable by using user access as provided by NIC. Full stop. Next para. Within the 48-hour window of taking objection, comma, the petitioner pointed out that there was no mechanism in place for the respondents to ascertain whether the amount of money, whether the payment was coming actually from the account of the bidder or from some other account. Full stop. Although the respondents responded to such objection, comma, the objection was turned down. Full stop. It is argued that the very purpose of transparency will be negated in view of the respondents having no mechanism to verify whether the amount was being paid from the concerned account of the bidder. Full stop. It is submitted that cartelization would also be encouraged in such manner. Full stop. Next para. Learned counsel for the respondent authorities submits that the petitioner has not pointed out any particular instance of violation of the provision by payment from some account which did not belong to the bidders. Full stop. Moreover, comma, the petitioner himself failed to qualify in the technical bit and has now preferred the instant challenge. Full stop. Next para. A perusal of the relevant clauses of the NIT indicates that undoubtedly the same envisaged that the payment was to be made using the bank account of the particular bidder. Full stop. Next para. However, the question as to whether such clauses were essential for the NIT depends on the perception of the tender issuing authorities stroke employer and not the participants. Full stop. It has been held time and again by various high courts and the Supreme Court that the employer stroke authorities are the last judge of the weight, Ujun, which should be placed on the tender clauses. Full stop. Next para. That apart, comma, no discrimination has been meted out, METED, meted out to the petitioner or any particular bidder, since the absence of such mechanism of verifying each account was not in was applicable not only to the petitioner but all the bidders universally. Full stop. Next para. The apprehension of cartelization of the petitioner cannot also be accepted in toto. Full stop. Taking, for example, a case where a particular bidder was sponsored by a third party, comma, who was encouraging cartelization by funding several bidders, comma, it would be an easy way out from the requirement of the tender for the said sponsor to park the necessary amounts to each of the accounts of the particular bidders who were proposed to be sponsored. Full stop. In such manner, comma, even if there was a mechanism in place to verify the bank accounts from which the amount was sourced, comma, there would be no way for the tender issuing authorities to apprehend as to whether the funding was done by a third party cartel, CRTL, full stop. Next para. There being no requirement of the tender issuing authorities to go one step further and verify the source of the fund in the account of the bidder, comma, the stipulation sought to be mandated by the petitioner, comma, in any event would not be a sufficient safety net against cartelization. Full stop. Thus, comma, this court is of the opinion that the decision lay with the respondent authorities to decide whether the clause regarding payment from the account of the bidder himself was essential to the NIT. Full stop. That apart, comma, as rightly argued, comma, no particular instance of violation has been made out, comma, which renders the present challenge merely academic. Full stop. Next para. In such view of the matter, comma, There is no scope for interference. Accordingly, WPA 25211 of
My
2023
lord, I give you the example of two accounts of the two bidders also. That I
is dismissed. Yes. Thank you.
grateful.
Or yes.
Lordship, before takes up original side matters, item number 20.
Of the appellate side?
Appellate side, item number 29. It's just, I think we could have time today. Yes, I am the respondent principal.
It will be called on when it is called on tomorrow.
Your Lordship, that's why I'm not there tomorrow. Could
If
be taken up
somebody is to ask for time, we cannot decide that now. I'm
Your
taking up
Lordship,
original side.
Monday, that's good.
May I have your lordship's kind indulgence, my lord, to mention, my lord, an original side matter.
Yes,
my lord.
yes.
There is an urgency. I am praying for a leave in respect of a particular matter, my lord. Coal is being coming from Nagaland, passing through West Bengal to Bihar. Your lordship has dealt with these matters before.
Yes.
SOP issued by the state of Nagaland has been fully complied with. All documents are there with the driver, my lord. But they are not, they have stopped the vehicle in the Kuch Bihar border. And my lord, they are in, I do not know what is their demand.
It is appearing in the list.
But I am praying for leave to file and immediately move, my lord, tomorrow, because the e-way bill has already expired. Again, it is extended. It will again expire on 4th.
Very well. Leave is granted. This will appear tomorrow at the top. And if there are other matters at the top, it will appear after that.
Very well.
May I be
I
permitted?
will serve and come, my lord. I
Please
will
do.
leave to short serve, my lord. Leave to short serve.
Yes.
May I be permitted to mention, my lord? My lord, this is an extension of interim order
Original
application.
side.
Yes, my lord.
You want inclusion?
Yes, my lord. My lord, the matter is supposed to be taken up, the original rate, on 6th. My lord, the interim order is expiring today. My lord, and my humble...
What is the item number?
My
Oh,
lord,
it will appear on 6th.
on 6th, my lord.
No,
I've
but
already
that-
served applications, my lord. My lord, day before yesterday, Dr. Chapulesh Bandyopadhyay, who is the senior in this matter, he was online, but due to technical glitches on the part of High Court, he was not audible to your lordship when he had prayed for extension of interim order. As a result of which, it has not been included in the your lordship's order of day before yesterday. That is why the extension is prayed for.
Then it appears to be mentioned for extension tomorrow.
Well, tomorrow he's not there. He's before the long.
Then it will appear on 6th.
6th only. Well, I'm praying for 6th only.
It has been directed to appear on 6th.
No, original matter, Manoj. The extension of
Original matter, when the original matter appears, I'll hear it out. No extension.
Manoj, extension has
I'll
already
hear
been
out
filed,
and dismiss your writ petition. So there is no question.
Manoj, extension of interim order application has been filed, Manoj. I am praying for inclusion.
Acha, very well. This extension application will appear along with the main matter or
My lord, that is my humble prayer.
applicationটা দিয়ে দিও application ফাইল করেছো ওটা 17 তারিখ যখন
It
আসবে
has
তার
been
সঙ্গে
served also, my lord.
very well thank you
Listed matter, original side item number 1 for hearing, West Bengal Power Development Corporation Limited and another versus the Nvidia.
My lord, petitioner, my lord.
I'm
If
for
we
the
continue-
respondent.
On the last occasion that I was arguing, Yes, yes, actually, we my lord, this has got sometimes to the oblivion. And my lord, it could have been, I do not know whether I can complete by this short period of time.
come ready with the written notes of arguments and complete your arguments just remind me and complete your arguments exchange written notes
My
and
lord,
come.
I think
because I've already lost track of it
no, I'm not telling that, not
no I am telling that
my lord,
no you make your oral arguments also conclude your oral arguments
Yes.
on the next day
For written argument, my lord, I need a week's time at least.
I'll give you that. Both of you come ready with your short written notes of arguments. When you file your written notes, simultaneously conclude your oral arguments also.
Well,
so that I can wrap up the matter.
Yes, petitioner has already
Will complete your oral arguments.
Yes,
He'll give his very short reply.
Yes.
And you'll file your written notes of arguments.
My lord, can it be settled any time? Achha, 1 week up.
Tell me the date. Give me the date when you can come.
1 week,
to
you know, we are in some hurry, which is why we are only mentioning. No, we are also in hurry because we are also Then 1 week is forgetting. fine. Forgetting also the things. What to say?
Apart from me, everybody is in hurry in this. So I'll keep it on December 7th then.
My lord.
After 7 days, after 6 days, 7 days.
My lord, on
7th December.
Yes.
Due to paucity of time, the hearing cannot be concluded today. Full-stop Learned Counsel for the parties are requested to come prepared with their written notes of arguments and conclude oral arguments on the next date. Full-stop. The matter shall be listed fairly at the top on December 7, 2023. Thank you.
Grateful.
No, sorry.
Court application. Item number 2, Graham Food and Hotel Private Limited versus Union
What
of
is the
India and others.
What about service?
My lord, we have served.
Affidavit of service, file the affidavit of service.
Your Lordship, we are appearing for the respondent number 2 to 5. We are praying for a short passover.
Why? What is the question of short passover? You have a 3:30 today. 14 minutes are left.
Your Lordship, the senior appearing in this matter is actually currently in a hearing. Kindly grant a short pass.
Short passover has no meaning. Then come back tomorrow, Mr. Ali. What can be done?
Grateful, Your
I'll
Lordship.
record the data. Affidavit of service filed today be kept on record. Full stop. And adjournment is sought. You are for the IRCTC.
Yes, Your Lordship.
This is the second occasion. This is the last chance to you. An adjournment is sought on behalf of the IRCTC when the matter is called on for hearing. Full stop. As a last chance to the IRCTC to contest the matter, the same is adjourned for the day.
May it retain its position.
Yes, it will remain in the list tomorrow and come back tomorrow. Let us see.
Grateful.
একই তো পজিশন থাকবে নাকি? একই তো পজিশন থাকবে। যেগুলো টপে ঢোকা সেগুলো টপ।
Review application. Item number 3 to 5.
My lord, I appear in item number 3.
Move the matter. You, Mr. Banerjee.
Lord.
Yes, Mr. Banerjee, move the matter.
Yes.
I've granted time on earlier occasions. Now you are to urge. That was the
Lord,
understanding.
challenge to orders passed by the identification committee.
You're led by somebody in this matter.
Mr. Jishnu Chaudhary, my lord, is leading.
What's it? This is different from 6 and 7.
Your lordship, 4 and 5. Yes, your lordship.
I'm sorry for yes.
Yes, your lordship.
But 4 and 5 is my matter.
Yes.
It's coming for the first time.
My lord,
Let me
affidavits
hear
are-
this.
No, my lord, what I was respectfully submitting. Lord, if your lordship hears 4 and 5 and passes, if your lordship thinks it's fit that an interim order, and then all three can be heard together. This
He's
is all I
saying it
was
is different from 4 and 5.
Lordship.
They are same.
He may think it's different, but I don't
You don't think
it's-
so?
I don't think so.
This
If
was the
same
point
order,
taken in the appeal court also.
কি বলছো তুমি? Different কি করে হলো?
Lordship,
What is your take on the matter?
Here, my lord,
Different or same?
Lord, here what had happened, that initially the writ petitions was heard together. And my lord,
If I
they
may
had
just take 2
suggested,
seconds of your 2 minutes. I'll tell you.
Opposition has been directed in the other matter.
Yes.
So you want a
Yes,
similar direction in
Lordship,
your
in
matter?
item number 3, the affidavits are complete. It is ready for hearing.
That's what I said.
So how
And
soon
my
can
lord,
you
with
file
the
your-
interview, I'll tell you, Lordship, my lord, there were 5 writ petitions that were filed. 5 writ petitions, but the 5 notices in willful defaulter matters. So the order of willful defaulter passed by the second committee and the first committee were
The
challenged
alleged
by
default is the same company.
same company. There were 2 promoter directors and the rest were executive directors.
on
One is
different
the
footings.
corporate
Yes.
guarantor, different footing.
But the same transaction.
Transaction same period, same order. By one order, all 5 were directed.
What interim
to be
order are
willful
this,
default. I'll
Chaudhary?
tell you, Lordship, kindly.
Yes.
Lord, your Lordship initially passed an interim order. All 5 were heard together. One interim order was passed, which was made applicable to all the writ petitions.
Right.
The interim order continued till the disposal of the writ petition. While disposing of the writ petition, your Lordship effectively heard the promoter director's writ petition. And my lord, what had happened is, Lord, the order was followed in the other writ petitions. Well, with 3-4 months have elapsed when we argued, then Mr. Shah argued. This has happened. Now, appeal, 5 separate appeals. Your Lordship, what your Lordship did, upheld the order of the second committee, the review committee. So, my lord, 5 separate appeals were preferred.
Yes.
My lord, initially the appeals of the promoter directors were being heard. My lord, thereafter, my lord, one of which is item number 3 here.
3 is the promoter director's item.
No, the other director, independent. He said that my stand in a different footing since all
not considered well.
So this wasn't been considered.
Yes.
So, my lord, give me liberty. Judge, the appeal court said, very well, I'll give you liberty.
Review.
Go apply in review and you will have. So, my lord, there was an interim order in the appeal as well. The same that your lordship had passed. Effectively the same. So, my lord, that was that. Based on that, they filed item number 3, which was a review application. My lord, on the next day, my lord, it was pointed out that the other 2 matters, apart from 5, 2 which is now before your lordship, item 4 and 5, we pointed out the same issue.
This was also not considered. Then the Honorable Chief Justice said that then what's the point? We'll pass the same order. We'll give you the same liberty. You go before the Honorable Single Judge and take the same point. If he considers then...
You don't have an appellate court order.
I do. I have an identical order.
Oh, then yes.
I have an identical order and on the same footing.
What is the interim order being enjoyed by them?
Look, I am more scared of Mr. Bose than of the bank. Look, because I'll tell you, Lordship, I have a point which he can't have. My issue is that I was not a director of this company at the relevant time, and the bank did not understand this when they issued the show cause notice. So I am on a totally different footing.
You are a guarantor or what?
Nothing. Look,
Nothing?
there was another company where there was no financial assistance. I was.
You are neither a director nor a guarantor nor nothing in this.
Now,
you are roped in due to some other transaction.
Yes, and I'll tell you, Lordship, why I was roped in.
Then Mr. Bose, I'll hear out Mr.
Yes,
Chaudhary.
I'm
matter.
totally separate. Now, after Miller, I succeed. He uses my order and he's trying to write piggyback on me. I don't want that. I am on a separate footing. The second a promoter comes in, I'll get into trouble.
You are not a promoter, nothing.
I was not a promoter. I was not a director. I was a director of another company.
Then I'll hear out 3, Mr. Bose.
Yes, I want to be separate from Mr. Bose.
Your Lordship will not hear out 3.
No, I'll hear out 3 right now. I mean,
Yes,
your matter after that.
Of course.
Your matter I may not entertain also. So, therefore, there is a question of directing.
Possibly he doesn't know the facts of my matter.
No, I don't.
Well,
You
I
are
am
right.
also not a promoter director.
You are what?
I was a director, but I was an executive director. I was a
Director of
professional
this company. He was nothing. I mean,
Mr. Bose had appeared for all of them. Today, my lord, the house is divided. But my lord, when
might have appeared for all, Mr. Shah, but
yes, but no, but my lord, I do not understand. My
the
lord,
capacity is there. Mr. Chaudhary is saying the capacity is between his client and Mr. Bose's clients are different. I mean, he was not concerned with the body.
correct, but Mr. Bose had represented all of them.
Maybe
in the first round. Today, my lord, Mr. Bose, my lord, says that, my lord, he disowns that client.
No.
If his
Mr.
fight
Chaudhary is disowning Mr. Bose.
Not what I have said.
Not the other way around. Mr. Chaudhary is disowning Mr. Bose.
Correct.
He's apprehensive that Mr. Bose's vote may sink him also.
Yes, that's what happened.
If he says on the same footing. So he's saying he's on an entirely different footing.
My lord,
You are for the bank.
I am for the bank.
Oh. You are the storm.
No. My lord, I'll make
They
my
are scared of their boats and you are the storm.
My lord,
Bank is the storm. Mr. Shah makes it the cyclone.
my lord, all sailing in the same boat. Now they have, my lord, separated themselves into one into a raft, one into a rubber dinghy. I'll make my submissions on that.
Lordship gives me 7 minutes, I'll finish today.
7 minutes? You have rehearsed.
For 7 minutes,
You
I'll
have
finish
rehearsed.
today.
You have rehearsed before the.
No. We are very short matter. Very short matter.
Wait.
Milord, Milord, I have prepared.
That's it now.
I'll copy it.
Handed up.
Yes.
Soft copy now. There are a short list of dates, Milord.
Give a copy to Mr. Shah also.
Yes, I will. আমি বহুবার বলি 4-5 কপি করে করো তোমরা আমি তোমায় এক্ষুনি ঠিক আছে মিলট বার করো তাড়াতাড়ি করো
3 শুধু 3 দেন হ্যাঁ 3 থেকে 5 দরকার নেই
তিনটা দেখি ও আচ্ছা আমার টিফিন মিলট there are 2 companies concerned. One is EMC Limited and one is EMC Infrastructure. My client, Milord, was not a director of EMC Limited. He was a director of EMC Infrastructure at the relevant time, which is 2016-17. Allegations for Milord declaration as willful defaulter is in respect of EMC Limited for the year 2016-17. My client is not a director. Subsequently, after 2016-17, at one point of time, EMC Infrastructure merges into Limited, and the resulting entity is known as Infrastructure by a name change subsequently, which is why, my lord, the bank made the mistake. The bank saw that I am after merger, saw that I am a director of infrastructure and assumed I was there with EMC Limited in 2016-17 when, Milord, which is the time?
When did the merger take place?
2019.
That's a part of the
26 February 2018.
Oh yes, it's there. Yes.
Milord, I am
Right,
really, I've made the list of dates, Milord, which I have misplaced. Milord, I handed
You
up.
don't have a copy.
No, Milord, that's why I couldn't read it. I thought I would hand up. I'm very
You have a
sorry.
soft copy.
That's what we copy. Soft copy. 8th. Milord, kindly see the first date. Milord, may I place it? 22nd March 2014. Milord, I joined as a director of infrastructure. My DIR 12 is at page 16. Then, Milord, 26 February 2018 is the merger. The order is at page 60. Order of infrastructure with EMC Limited. EMC Limited was dissolved without winding up. So, Milord, the resulting company is infrastructure now in 2018. Then, name of infrastructure was changed to EMC Limited.
No, the resulting company was
infrastructure. Milord, 14 is when I joined infrastructure as a
All right,
director.
yes, right.
18, Milord, limited. It's very complicated, Milord. Infrastructure joins limited. Limited is dissolved without winding up. So, Milord, what remains is infrastructure with the two businesses together, EMC and infrastructure. Then, Milord, this is February 18. Then July 18, infrastructure's name is now changed to limited. So, Milord, after Milord July 18, the name is EMC Limited, and it's now two companies, infrastructure and limited, in the process which I have shown. Then, Milord, show cause 6 July 2018, the name change. 8 February 2019, show cause notice issued to the petitioner by the bank, which is at page 100. The allegations contained in the show cause notice pertain to financial year 16-17. So 16-17 is prior to merger and 16-17 pertains to EMC Limited. That's, Milord, very clear from the show cause notice. I was not a director. I was then a director of infrastructure. So, Milord, there's no question of roping me in. Then the other, Milord, I was identified. I gave a reply. I've said this in the reply. So my argument is this, without, Milord, going into any further facts, that I was not a director. In the show cause notice, if you wanted to include me, you had to say how I was involved. You don't even say that. Director is presumed to be involved in the business. So if it's a director, you don't have to say how he was involved. But here, Milord, I wasn't a director. So I was not involved. You haven't said what is my special involvement. This is my only point. I'm a professional. I want to get out of this. Which is why I want to disassociate from, Milord, Mr. Bose. Mr. Bose was earlier, Milord, doing it for everybody. When these notices came, all the people involved said, we'll all do it together. I joined them. But then I discovered that I am, Milord, being prejudiced because I don't want anything else to be, Milord, considered also. I wasn't there. You can't involve me. I'm a professional. I don't think Mr. Shah would, Milord, really go against me. He'll go against the rest of them. Milord, these are my humble
We'll
submissions.
continue tomorrow then.
Yes.
See that. Hard in part for further hearing tomorrow, Mr. Shah.
I'll try to work on Mr. Shah in the meantime.
Point is, I'm a structured organization. My lord. I can't
No,
even
no,
go to the bathroom without my board's approval.
Because this is a very clear situation where he has nothing against me.
Apparently, yes. Subject to hearing, Mr. Shah. Let him complicate it tomorrow.
Great.